All right, we're going to go ahead and call Senate Commerce and Labor to order. Madam Secretary, please call the roll.
Senator Hardy? Here. Senator Lang?
Here.
Senator Neal? Here. Senator Pickard?
Here.
Senator Scheibel? Here. Senator Settlemeyer?
Here.
Chair Spearman?
Thank you. Mark Chair Spearman absent. She will not be here for this entire meeting. She may pop in on a Zoom, like way late, but she's absent. So, good morning, everybody. The agenda is going to be very different. We're not going in order at all. So I'm going to tell folks the order so they can plan their time. We're going to do AB 207 first, AB 190 second, AB 210 third, and then AB 298 fourth, and then AB 200 will be the fifth bill and the last bill for the hearing today. So we will go ahead and open up for AB 207 and call Assemblyman Watts to the table.
Thank you, Madam Vice Chair, members of the committee. Good morning. For the record, I'm Howard Watts, representing Assembly District 15 in Clark County, and I appreciate the opportunity to present AB 207 today. I'm joined on Zoom by David Brody of the Lawyers Committee for Civil Rights Under Law. I'll speak briefly on what motivated me to bring this measure forward and the intent of the bill, and then turn it over to Mr. Brody to provide some additional background and context. In 2011, I was involved in an effort assisting members of our LGBTQ+ community in the effort to update our state's non-discrimination laws to be fully inclusive. There were three key policies that we looked at that time: employment, housing, and public accommodations laws. And we were successful in making those updates, making us an early national leader in providing legal protections to all Nevadans from discrimination. Nevada's current public accommodation law protects us from being discriminated against based on our race, color, religion, national origin, disability, sexual orientation, sex, gender identity, or gender expression at places where the public is invited or where public use is intended, including most businesses. However, the law has not kept pace in the ensuing decade, as a greater share of our interactions have moved from brick and mortar to the digital realm, a shift that's been clearly highlighted by the pandemic. AB 207 addresses this by clarifying that our public accommodation protections apply to e-commerce. Section 1 defines online establishments and adds them to the definition of public accommodations for the purposes of our non-discrimination laws. And in the first reprint of the bill, we made an adjustment to try and clarify that that definition would not place any additional requirements on existing brick and mortar businesses as applies to their websites. Section 2 of the bill looks to mirror an existing exemption for some private clubs by defining and including private online chat forums with fewer than 1,000 members. Ultimately, this is, again, about trying to make sure that there's parity. Many of our online interactions are actually, I would say, more secure from acts of discrimination because they happen almost instantaneously. Something's offered, there's a transaction that occurs, and usually there's no personal interaction. But when that discretion does exist, we want to make sure that if somebody can't be discriminated against when they go into a brick and mortar business, that they can't be discriminated against in an online business that's essentially offering the same good or service. So with that, AB 207 aims to cross the digital divide and level the playing field so that all businesses operating in this state are open to all Nevadans. With that, I'll turn it over to Mr. Brody to provide some additional context, and then we'd be glad to take any questions that the committee may have.
Good morning, and thank you for inviting me. My name is David Brody, and I lead the Digital Justice Initiative at the Lawyers Committee for Civil Rights Under Law. The Lawyers Committee is a nonprofit, nonpartisan racial justice organization founded in 1963 at the request of President Kennedy to combat discrimination and inequality of opportunity. Our Digital Justice Initiative works on issues at the intersection of civil rights, privacy, and technology, such as discrimination in online commerce, internet-enabled hate crimes, and discriminatory uses of personal information. Public accommodations laws are a cornerstone of civil rights protection in the United States. These laws are one of the key mechanisms used to end Jim Crow segregation and discrimination in everyday commerce. Many of these laws were enacted during the civil rights era in response to protests, sit-ins, and boycotts by Black Americans and others seeking equal rights. Today, if a business posts a sign that says whites only, it should not matter whether it's written in ink or pixels. The discrimination is the same, the harm is the same, and under Nevada law, the legal consequences should be the same. Public accommodations laws are general purpose anti-discrimination statutes. They state that if a business offers goods or services to the general public, they must serve everyone, regardless of race, sex, religion, national origin, sexual orientation, disability, or other protected characteristics. Classic examples of places of public accommodations include hotels, stores, restaurants, theaters, buses, and stadiums. These laws, including Nevada's, typically prohibit two forms of discrimination. First, they prohibit covered businesses from denying service or charging higher prices on the basis of protected characteristics. Second, they prohibit violence, threats, or harassment by third parties when someone seeks to patronize a business. To give the historic example, these laws both prohibit a lunch counter from refusing service on the basis of race, as well as prohibit a racist mob from blocking access to the lunch counter. Despite all of our advances on civil rights, discrimination and hate continue today. We have seen it recently as hateful threats and violence targeting Asian Americans have spiked nationwide. These types of incidents interfere with our equal enjoyment of places of public accommodation by intimidating our neighbors, especially senior citizens, from feeling safe when they go out in public. These harms occur online as well. Online threats, harassment, and intimidation frequently target people of color, women, LGBTQ individuals, religious minorities, immigrants, and people with disabilities. The Pew Research Center recently reported that 40% of Americans have experienced online harassment and that 25% have experienced physical threats, stalking, sexual harassment, or sustained harassment online. These hateful acts interfere with the right to equally enjoy online commerce. They discourage speech and civic engagement, and they cause serious harm. Businesses suffer when customers are not safe. When a user self-censors or stops using a website because they are being threatened, that user is deprived of their right to enjoy the services offered by that business. Discrimination also continues to infect the marketplace, where consumers of color continue to receive worse treatment and experience unequal access to goods and services. This discrimination increasingly occurs through online business practices. For example, Facebook, Google, and other major tech companies have been sued or investigated repeatedly for discriminating in their advertisements for housing, employment, and credit. Retail websites have been found to charge different prices based on the demographics of their user. Communities of color are targeted by predatory and low-income for-profit online colleges. And algorithms that set car insurance rates have charged minority neighborhoods higher premiums than white neighborhoods with the same risk levels. Absent anti-discrimination protections, online businesses can refuse service on the basis of race, charge higher prices on the basis of religion, provide subpar products based on gender or sexual orientation, or ignore the accessibility needs of people with disabilities. Public accommodations laws are meant to close these gaps. However, because most public accommodations laws were written decades before the invention of the internet, they do not always apply equally online and offline. AB 207 seeks to amend the state's public accommodations statute to ensure that Nevadans receive the same protections against discrimination from billion-dollar websites that they do in a mom-and-pop corner store. Currently, 5 states explicitly apply their public accommodations laws to the internet: California, Colorado, New Mexico, New York, and Oregon. So Wall Street and Silicon Valley are already covered in their home states. Our analysis shows that another 17 states have laws that are likely to apply to the internet, but the courts have not addressed the question in those states. For Nevada's statute, our research shows that it is unclear whether or not the state's public accommodations law applies to online businesses. This legislation clarifies that. Just about all Nevada brick and mortar businesses must already comply with your statute, even when operating their own websites, but it's not clear if online-only businesses would be covered. Passing this bill would level the playing field between online and offline commerce, requiring online businesses to meet the same non-discrimination requirements as your physical businesses and protect the rights of all your residents. Thank you, and I am happy to answer your questions.
Thank you. And with that, Madam Vice Chair, we're glad to take any questions that you have. I also did want to let you know that I will not be staying for closing remarks. So after questions are done, I'm going to get back up to my other committee.
Understood. Senator Pickard, and then after that, Senator Harding.
Thank you, Madam Chair, and thank you for your presentation. Honestly, I'm struggling with understanding why we need the bill. The examples that were just given, like lunch counters, that doesn't apply to online businesses. So much of the examples, I think, were inapposite. But my concern is this: when we use the term public accommodation, that is used well beyond the scope of the kind of discrimination that was described here today. I'm thinking, does this then expose, or doesn't this then expose purely online entities to ADA complaints? I can see if we were saying that there's something wrong with their website, that you can't really navigate it because maybe the font is too small, or the colors are bad for the colorblind, or something like that. All of which can be usually addressed in the browsers. This bill is going to be a trial lawyer's dream. I mean, I am one, and I'm thinking, man, if I were still in injury law, I could sue nearly every internet site that I encounter. And yet, we already have laws on the books that expressly prohibit discrimination in all the forms that were described. So can you give me a better example of a group of websites that this is such a widespread problem that we need to expose every single website to a lawsuit or potential lawsuit?
Thank you for the question, Senator Pickard. Howard Watts, for the record, through you, Madam Vice Chair, to Senator.
Just go direct.
Thank you. I can give you a great example. So right now, if somebody decided to operate a bakery, brick and mortar, or a photography business where they do event photography, and they have a small little brick and mortar retail establishment, and someone comes in and asks for pictures or a cake for their wedding, and they are denied on the basis of any of these protected characteristics, that service, then that is a violation of our public accommodations law. However, if someone offered those services exclusively online and chose to make that denial for the same reason, it's unclear whether our law protects that. So that's what this bill is seeking to address. Now, in regards to your question about websites, again, we added an amendment in working with some of the other stakeholders from the business community to clarify that folks that are already operating here in the state in brick and mortar, that this would place no additional requirements on them, and the intent has never been to place additional requirements on websites. You mentioned the ADA. That, of course, is a federal law, and so no state action that we take is going to make a difference one way or another into how that law may or may not be applied to accessibility on websites. So, we've worked to clarify those issues, and again, this is not necessarily about accessibility. It's about when there is human interaction on a website and discrimination could be proven under our existing public accommodations, non-discrimination statutory framework, and they'd have to essentially bring civil action seeking relief from that, and they'd have to bring evidence to support that. We're just making sure that Again, that online business that operates 100% online in offering their services is held to the same standards as a brick and mortar business offering those same goods or services.
All right, and I appreciate what you're saying, and I agree with the theory that everybody should be on the same playing field in terms of non-discrimination. But what I'm not getting is, let's take brick and mortar facilities off the table because it already applies to them. They are public accommodations. But if we, under this proposal, establish all or any online establishment that's exclusively online as a public accommodation, we're establishing that the entity, the entire operation is a public accommodation, and now they are subject to, and I would respectfully disagree, we can sue in state court on state law on ADA concerns because we have a comparable set of laws here. This would open the door to an online establishment having liability on their premises. And so this would be greatly expansive in terms of the impact on businesses. But let me ask my question a little differently because what I want to get to is how is the law we have today insufficient? Because we have public accommodation law, we have non-discrimination law. Where is the gap? Can you point to it?
Thank you for the question, Senator Pickard. Howard Watts for the record. First of all, I'd respectfully disagree with you and note two things. This is amending NRS Chapter 651, and so the intent is that it's limited to the confines of that chapter. I know public accommodations are discussed in many places in statute. This is just seeking to amend that chapter, which really deals with issues of discrimination. And to your second question around what gap is this addressing? If you review that existing section of law, it is completely silent on whether it would apply to e-commerce. Much of the language talks about being operated from a physical location, places where the public is invited or where public use is intended. So it is not clear, and the analysis done by Mr. Brody's organization has indicated that in many states it is unclear whether these protections would apply to Nevadans engaging in commerce with online-only businesses. So that's what this bill is seeking to fix, and if you have a suggestion for tighter language, please do send that along.
Let me just ask one more question, if I may. Mr. Brody, does your firm pursue these cases in litigation?
We do bring civil rights suits under a number of different statutes, including public accommodations laws.
So this bill would directly improve your client base pool, correct?
It could if we end up bringing anything in Nevada.
I have no
To
further
my
questions.
knowledge, I'm not familiar with any cases we've brought under anti-discrimination laws in Nevada. And if there was, we use a variety of statutes, but the short answer is yes, it could.
Thank you for that, Senator Hardy, and then Senator Settlemyre.
Thank you, Madam Vice Chair. So my question's a little simpler. I look at it as not operated from a physical location in the state. Switch is definitely operated in a physical location in the state, and all of those wires and semi-wires, and they're all in the state. So would this apply to Switch?
Thank you for the question, Senator Hardy. Howard Watts for the record. The short answer to your question is yes. Switch has physical locations located in the state, although for anyone who's visited Switch, they're not it's not exactly, their facilities are open for public access. They're highly secured. However, I think one of the things that you're speaking to is the fact that there may be businesses that operate online but do have some sort of physical location here in the state. This is something that I've actually been talking with some of the stakeholders as well as legal about, and we may bring an amendment to clarify that intent further, to indicate that, again, if you're already operating a brick and mortar that would apply as a public accommodation, this is not seeking to put any additional requirement on your business. If you're operating entirely online in the digital sphere, we just want to make sure that those interactions are held to the same non-discrimination standards as they would be if they were being offered from a brick and mortar location.
So my point on Switch is they don't control who comes into them and who goes out of them. Help me out.
Thank you for the question, Senator Hardy. Howard Watts for the record. So in that particular instance, you're discussing data centers and what would happen. I think you're referring to they're hosting certain entities and what happens if there's discrimination from one of those entities. Switch wouldn't be liable. It'd be the company that is directly interacting with the consumer that has an issue of discrimination. This is not intended to apply to hosting services or data services such as Switch.
Senator Settlemeyer.
Thank you, Madam Vice Chair. I was just kind of curious, you brought up the discussion of, photography and things of that nature. So what if an individual for their wedding, whatever, they send off the photos to another country, or, they go online, they find a place that creates the cards to say thank you for showing up to the wedding and things of that nature, and they find out that they've been discriminated against. How will the AG go after a business that's completely domiciled in another country?
Thank you for that question, Senator Settlemeyer. Howard Watts for the record. We did receive some questions about civil action and how to proceed if the entity is not physically based out of the state of Nevada. And there's quite a bit of case law to describe how those cases would be pursued and have been when there are conflicts, even if not all the residents are within the same, or not all the entities are within the same state. As for international law, that's something I'm less clear on. So we'd probably have to ask legal counsel for some additional clarification there.
I appreciate that, Assemblyman, because that's my concern. So much of the digital stuff is generally not done in the United States of America. It's being done in other countries. When you go on to Vistaprint and things of that nature and have wedding cards printed up or things of that nature, you may not be dealing in the United States at all, and most likely you're not. And I can attest to that just based on where it gets shipped from, anything I get in the mail. Thank you.
Thank you for that. And if I may briefly just add an additional clarification, that's something that would have to be looked into on a case-by-case basis. And again, some of the activities may be outsourced outside of the country, but the business itself may have a license and be based, have a principal headquarters somewhere within the United States. That would likely, if an act of discrimination occurred and action needed to be taken, that would likely be the most likely avenue would be to pursue it within the United States.
I appreciate that. Again, my concern is out of the country. I had friends of mine that were same-sex marriage, and they wanted a plate made up, and it was in India, and they refused to do it based upon their disagreement with it. And I'm just curious how you're going to go after India, how you're going to go after a whole nother country, because their cultural beliefs are quite different than ours. Thank you.
Thank you for that. Will, Mr. Keene, would you like to comment on that? That I think there was one interaction at the beginning on a legal question, or no?
Thank you, Vice Chair Neal. Certainly, my name is Will Keene, I'm Committee Counsel for Senate Commerce. As far as the reach of this law, there's nothing wrong with Nevada enacting it. There's going to be limits on how far Nevada can reach. The International Shoe, Asahi Metals, and Worldwide Volkswagen cases are still a law of the land. I know that the Supreme Court recently issued an opinion, which I have not yet had a chance to read, revisiting those rather well-known cases as far as how far United States law can reach once you're entering the stream of commerce. Certainly, this law would only purport to apply to websites that were actually available in Nevada. And so what we'd have to see is whether that's going to be sufficient contacts to support jurisdiction. But there's nothing wrong with Nevada passing law, because obviously some of these entities are going to have sufficient contacts. And when they don't, then the case will fail on jurisdiction. Thank you.
Thank you for that. Any additional questions? Senator Scheibel.
So I have two questions, and the first is that I'm thinking that this might cover a gap in the law that addresses businesses that are conducted entirely online. I just want to check my understanding, because I get that a lot of online businesses still have that physical component. They're mailing you a product, something like that. But and now, of course, my memory fails me for a time it's happened. But I have certainly been on a website, wanted to read something or access something and put in my credit card information, and then had access to an article or a subscription, or I think there are actually like newspapers and news sources that have gone completely online at this point in time and no longer publish physical copies. So are those the kinds of businesses that this bill would be targeting?
Thank you for the question, Senator. Howard Watts for the record. I would say yes, and it would be in both regards, because it would apply to complete 100% digital entities, as you're referring to, but also the example that I gave, for example, of photography services. We've seen, especially in light of the pandemic, more people working from home, not having a brick and mortar location that is just open for certain hours that people can come into to ask for goods or services. And again, our law is unclear on if you're operating without any physical location from which your customers interact with you, would you be protected as a Nevadan if an act of discrimination occurred?
Okay. So what you're saying is that the current law, if I am a photographer and I say, okay, I'm going to take photographs at the Main Street Park on Thursday, and I refuse to take these pictures at Main Street Park on Thursday because I learn later that this couple or this family is multiracial. You're saying that currently there is no law to protect that family because the photographer doesn't have a brick and mortar store and the park isn't liable. There's no place of public accommodation. So now you're saying that the place of public accommodation would be the website through which they originally booked me as their photographer.
Thank you, Howard Watts, for the record. Essentially, yes, that's correct. So if you operated a photography store, again, out of a strip mall, and you had a tiny place and people could come in to get your services, then I think no matter whether someone comes to you in person or online, because you have that physical presence, any discriminatory action you take is subject to our public accommodations law. However, if your only way of offering those services is through your website, and then you take that discriminatory action, our law is not clear at all on whether you would have any protection or recourse, and that's what this bill is seeking to address.
Okay, that makes sense to me, and that does seem like an important gap to fill in the law. And I just have one more question, if I may, on the disability piece, because I understand there's a difference between the ADA and, making reasonable accommodations versus actual discrimination based on a disability. And it's not my area of expertise, but I am just wondering, would a plaintiff be able to bring suit against, let's say, the same photographer doesn't make an accommodation for somebody who is, who has some kind of disability? Could they sue that photographer based on a discrimination theory because they couldn't access their services because of their disability?
Thank you for that question, Senator. Howard Watts for the record. That's an excellent question. I appreciate you making the distinction. This measure is specifically focused on acts of discrimination. So to the extent that federal or state laws apply to reasonable accommodations, this is focused on acts of discrimination based on disability. Now, could someone bring a suit making that argument? I'm sure they could, but would it be upheld as discrimination versus being referred to based on its reasonable accommodations? I think that is a distinction that would be made if a case like that were brought forward. So this bill is focused on acts of discrimination, so there would have to be discriminatory intent and action, whereas reasonable accommodations, doesn't have to be any intent, and so that's the balance that this law is seeking to address.
If I could have one more follow-up. So it sounds like what you're saying, again, we'll stick with the photographer. If the photographer simply cannot accommodate somebody's disability, they don't know how to communicate with them, they cannot arrange for the payment or the meetup, they would then have, a different conversation versus if I'm a photographer and I respond with an offensive email that says, I'm not photographing you because of your disability, I don't like your disability, it's, other insulting language, and therefore I simply refuse. Those two cases, presumably, once they get to a court of law, would be treated differently.
Thank you for that clarifying question. Howard Watts for the record. That is correct. This bill is seeking to address the latter example that you gave, explicitly discriminatory behavior.
Thank you.
Any additional questions? So I have a couple. So Mr. Brody, so I get what's happening in the bill, but what I'm trying to understand is this whole bill literally brings me back to law school. Like immediately when I read Heart of Atlanta, and I was just like, boom, what's happening? What are the cases that have distinguished Heart of Atlanta since 1964, which was a Title II case around public accommodations. And so what I'm trying to super understand, right, in this context of this bill with an online establishment, how do you deal with the argument? Because there was a Fifth Amendment argument that you're deprived of the right to choose who you would like to engage in your business, right? And so you're moving us into a new frontier of online. And there's still some legal arguments to be made in this world and in this context. So can you talk to me about the right to choose your client in an online environment and how this may be different than a brick and mortar rule applied to online? And I read I think it was a case in California, right, when they sued under their state statute, et cetera. But I think that this walks us into a different space. So can you address that first question?
Sure. David Brody for the record. Thank you for the question. Businesses have always had the right to refuse service on the basis of reasonable grounds for doing so. If someone is belligerent towards other customers, or no shirt, no shoes, no service, things like that. But when a business is a place of public accommodations, what the law has recognized for 50, 60 years is that there are certain criteria upon which you are not allowed to refuse service. You can't refuse service because of someone's race or sex or other protected characteristics. You can't charge different prices to people based on those protected characteristics. You can't serve white customers through the front door and black customers through the back door, as one of the famous Supreme Court cases discussed. And so businesses have a great deal of discretion in terms of like how do they want to advertise, what type of clientele do they want to curate, but there's a limit, and when they start to discriminate on the basis of these protected characteristics, that's when the law steps in and protects the rights of the public.
Thank you. And then my second question, so when we talk about, so under Title II, which to me, NRS 651, it walks these provisions into the door. So you could have an accusation that a business is acting under the color of law, right? Which triggers a state action. So in this context of us inserting online establishments into 651, which is public accommodations, how then would the, an acting under color of law be triggered and then a state action occur if someone alleges a race violation or something else?
David Brody for the record. So, typically when an entity is acting under color of law, and I'll caveat by saying I am not a Nevada law expert, and so I will defer to the advice of the committee's counsel and others. But generally speaking, when an entity is acting under color of law, that means that it's a state actor. It means that it's a state agency or a law enforcement officer or someone like that. When a private entity is discriminating, it's not necessarily acting under color of law, but the law still applies. So in the case of Title II of the Civil Rights Act of 1964, it applies to private actors whether or not they are acting under color of law. And then there are additional provisions of the Civil Rights Act specifically focused on state actors.
So thank you for that. I mean, I don't want to get into like a little law session, but I know that under color of law goes a little bit beyond state actors. Just there's a small caveat there, but I'll leave that there. So talk to me about the remedial actions that you expect to occur if somebody triggers this as a plaintiff. What then would be the perceived remedial actions that would come into play? Mainly because if somebody challenges under equal protection, right? It's an online establishment. It's not clear who was given access, right? Whether or not you're black, white, orange, or Muppet, you're not clear on who was given access. So the question that I'm trying to understand is, how do we discern that that this was a violation of equal protection and that you were not given that access? Because the current case law in the space, you at least have to try to apply that you were treated differently, at least invoke some kind of statistical measure, something that proves that you, Sam Jones, were not allowed into the online establishment. So talk to me, walk me that pathway, help me understand.
Certainly. David Brody for the record. So my understanding of the Nevada law is that it's an intentional discrimination statute, which would mean that the plaintiff has the burden of showing that the defendant intended to discriminate against them on the basis of their race or sex or other protected characteristic. And so the plaintiff has to acquire and put on that evidence. And there's various ways that could happen. There are certain types of online businesses where it could be very obvious what someone's race or sex was. So, for example, I'm testifying here through Zoom. I'm on video. You can see what my race is. You can tell what my gender expression is. You can make some assumptions about what my identity is. And so, similarly, other sorts of video programs. You could do similar. There's other types of businesses where, race or sex or religious information is disclosed. For example, on Google or Facebook, you can target ads based on sex. The platforms require their users to disclose their sex so that they can do that ad targeting. And then similarly, there's lots of information you could figure out, and there are entire fields of research around how certain types of information, whether it's where you live or patterns in names or other types of information, how that reveals someone's race or other types of characteristics. But the short answer is the burden is on the plaintiff to show that the defendant intended to discriminate on the basis of a protected characteristic. And then the remedy available could be damages. It could also be an injunction to order the defendant to change their business practices in order to stop discriminating.
Thank you for that. And then my final question is the commerce, right? And so I want to get into kind of like a small Commerce Clause discussion around the online establishment. Because it's public accommodations, but what I'm not clear on and what I'm trying to process. And I understand, Assemblyman Watts, you get multiple points for boldness because this is very new. How do we deal with, so all markets are not equal. I'm gonna put that out there. So when we talk about business presence, right? And Mr. Keene talked about International Shoe and drawing that in. But at the end of the day, the presence that they have within the state builds that nexus and that connectivity, right? In order for us to touch them. And so all online establishments, although you're plugging them into public accommodations, I do think that there could be an argument made around a couple of things. Number one, the market that they're playing in, and then how someone argues that they're being treated differently or there's a distinction between the public accommodation brick and mortar that you are assessing and then their online presence within that same context. And so can you talk about, I guess the only thing you really could talk about is your legal theory of what would happen if somebody challenged that, and then two, what are the doorways that have been open, I guess, since the California case or other cases that have tried to insert this into their public accommodation statute? And then I have a follow-up.
Thank you, David Broyd, for the record. With regard to the jurisdiction issue, again, I'm not an expert in Nevada law, and so I don't want to speculate too far, but what I would say is, depending on what Nevada law says about personal jurisdiction and how far it goes, as well as what the Constitution says about the limits of personal jurisdiction, like Mr. Keene said earlier, it would have to do with the degree of contacts that the business has with the state. So, for example, if there was an online-only business that was specifically targeting Nevada residents for some sort of product or service, right? Like they're marketing to Nevada residents in a very specific way. They are specifically going after that market. I think that there's a stronger case there for why an out-of-state business in that circumstance would have minimum contacts with the state. But again, I'm not an expert in Nevada law, so take it with a grain of salt. I apologize. I just blanked on your second question. Could you please repeat it?
We can leave it there because I want to get to something else. I really need to, I got to go to another place. So immediately when I read this bill, like the first time, and I read it like a month ago, and then I reread, and then I was just like, wait a minute. Because, and I'm going to take you to a tangential place. Because, and I mean that literally. So when I was thinking about this case, and I immediately triggered into Wayfair, right? And I'm not having a Wayfair discussion, but when you read Wayfair around Commerce Clause, there is a very distinct argument outside of Wayfair, outside of physical presence, outside of there's this conversation that they had in that case about something a little bit more than physical nexus. They talked about market competition. They talked about market distortion. They talked about a lot of different things where that in the fine lane of which it was dealing with the Commerce Clause, you're touching on a whole other, I would say, market competition and market activity that has not been fully I won't even say it's been fully legislated. It hasn't been fully legislated, nor has it been brought through the courts in a way for us to really understand how this impacts the Commerce Clause. And so I really want you to talk to me about, I am in Georgia. I have the opportunity to participate in something that's going on in Vegas, which is going on now. And I feel that I was discriminated against But the online establishment does not necessarily have a physical or principal place of business that exists in Nevada, but they are doing activity here. So how does that work when they start to argue that you're infringing upon me and this plaintiff has no real relationship to my business? They encountered it once or twice, and now they're claiming public accommodations and discriminatory behavior. What then do we do in those circumstances? Because that could happen, right?
Thank David Bray for the record. So if I understand the hypothetical, the plaintiff here is in Georgia. They interact with an online only business that is operating in Las Vegas, but the business itself is not based in Nevada.
Correct.
And they're trying to use this law. I think that's a situation where the exact facts would be very important, and the scope of Nevada's personal jurisdiction law would really come into play, and that's something I'm unfortunately not an expert on. I think though that that's a question that is sort of it's more of a jurisdictional question apart from this bill. I can only speculate on how Nevada courts would interpret that, and I don't want to go out on a limb on an area I'm not expert in.
So thank you for that, and I understand what you're saying, but it does invoke some jurisdictional questions because there will be online places that's in a jurisdictional framework. It inserts us directly in there. And so I will leave it at that. Thank you, Assemblyman Watts, for my morning coffee on law school redone year one. Okay. So Assemblyman Watts, Senator Settlemeyer.
Thank you, Madam Vice Chair. As you were talking, a couple of things came up, and I was just wondering, under Section 1, line 12, it talks about online establishment means a business, whether or not conducted for a profit. And I was kind of curious, whether or not conducted for a profit, would this then mean there are some online entities that do genealogy and things of that nature? So in that respect, would those type of entities now have to register and show and track same-sex marriages that are currently not, if this law were to be applied?
Thank you for the question, Senator. Howard Watts for the record. I might need a little bit of additional clarification on your question, but I will speak broadly to the first part of it, which is that already a nonprofit entity that offers goods or services broadly to the community from a physical location already falls within our public accommodations law. So the goal was to mirror that in the expansion into the digital realm.
All right, I appreciate that. I guess I'm just concerned I'll have to look into that a little bit further because, again, some entities out there do have very large genealogy type programs that help track family heritage, and they may not necessarily agree with same-sex marriages. And do they currently track those or not? Or do they show up within those type of programs? And then would this mean they would have to? And I guess that's my concern. I guess I'll have to take that offline. Thank you.
Thank you for that, Senator Settlemeyer. So, Assemblyman Watts, I actually have to ask you something on the bill because we need clarification on it. It's in Section 1, sub P. That it says a lot. Can you put on the record how P works?
Yes, thank you for the question. Howard Watts for the record. So looking at subsection P, it is, so any establishment that is operated from a physical location and physically contains or is contained within any of the establishments that are operated from a physical location described in paragraphs A to O inclusive, and which holds itself out as serving patrons of the described establishment. So there are some modifications, and the modifications in this are because we're adding online establishment. So we added additional clarity that P applies to physical establishment. So essentially what this is this is particularly applies to some of the entities within resorts that are clearly covered within public accommodations law. So we're trying to describe places that are located within places, there can't be any barriers to people accessing those. So a lot of the new language in there is just clarifying that to be, to maintain its original intent for physical location as we're adding online entities into this statute, into 651.
Okay, let me get this right. So you're saying if you're already operating a physical location, but then you're doing some online activity inside of that physical location? Is that what you're saying?
Thank you for the question. Howard Watts for the record. No, what I'm saying is that as we're adding online establishments into Chapter 651, these amendments were sought to clarify P to maintain its existing statutory framework, which is all physical. So that's why you can see that it's particularly added that is operated from a physical location and physically contains. So we wanted to clarify that entities that are operated online are not covered within P. So this is existing statute that was meant to include various brick and mortar entities within our public accommodations law, and we're just seeking to clarify that that's not being broadened out by the addition of online establishments under the bill.
Okay, thank you for that. Senator Pickard.
Thank you, Madam Vice Chair. And this discussion has been really interesting because like Senator Neal, I do frequently go back to law school when some of these things come up. And the discussion brought up the Masterpiece Cake Shop case in my mind. And I recognize that that was actually decided on an administrative law principle. But the dicta was pretty heavy, and as I recall, it was Justice Kennedy that wrote the opinion. And he pointed out that, and that was where it was an actual public accommodation. It was a brick and mortar shop. But they preserved for the individual the right to essentially, or he left open the door for the individual to decide who his customers ultimately would be. So as I look at this looks like it's an attempt to kind of clarify a position with respect to the dicta in the Masterpiece case. Wouldn't this further erode the individual's right to choose their customer? And I'm thinking the discussion was about the photographer, and this is what triggered in my mind the Masterpiece Cake Shop case. Wouldn't this then tell the individual who didn't have a brick and mortar operation, who maybe to use the idea of maybe he's he or she, the photographer, is a pastor or someone who's active in their church who, for whatever reason, I don't know any churches now that take this position, but they say, no, we can't condone same-sex marriage, just to stay within the cake shop case. It seems to me that Masterpiece stood for the idea that the person could choose their customer. Wouldn't this work against that now that individual, he doesn't have or she doesn't have a physical presence, but now she no longer can make that determination?
Thank you for the question, Senator. Howard Watts for the record. Just going back to some of the discussion that's already been had, folks do have the right to choose their customers. However, when they do that in a discriminatory fashion, state public accommodations laws can step in. And so, not being an expert on the nuances of that decision, my understanding is if a bakery was generally open to the public here in the state of Nevada, operated from a brick and mortar location, and clearly refused to provide service based on one of those protected characteristics, that's a violation of existing state law today. what we're seeking to clarify is that if those same services are being offered through a website only, and that same act of discrimination occurs, that our non-discrimination laws would apply there as well. So, I believe that there is a balance between the ability to choose one's customers and the responsibility to be non-discriminatory in one's activities. And that's really what this bill is seeking to address. So.
Great, thank you for that. So we will go ahead and open ourselves up for support for AB 207. Is anyone on BPS for the phone lines, AB 207?
Thank you, Chair. Support of AB 207. Please press star 9 now to take your place in the queue.
Again, if you would like to testify in support of AB 207, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 120, please slowly spell and state your name for the record. You have 2 minutes and may begin.
Good morning, Madam Vice Chair, members of the committee. Stephen Cohen for the record. Stephen with a V, Cohen as in the Assemblywoman. I just want to address a couple of the concerns that were raised during the Q&A and discussion portion. The public accommodation theory was most recently tested in California just prior to the 80th session, and ultimately it came down in favor of the consumer. Essentially, the business, which was a major pizzeria, said that because there were no guidelines on how to make their website accessible, that they were not subject to it. In addition, plaintiffs who, as have already been pointed out, would have the burden, would have the choice of law of where to bring the suit under these circumstances. In looking at the statute in the state where this particular pizzeria is headquartered, their statute, excuse me, under public accommodation is a lot less restrictive than ours. So if I was in that consumer's shoes, I would be bringing it here. And then, as has already been pointed out, Title III of the Americans with Disabilities Act, as amended in 2008, already covers this issue, but then we do have a similar framework in terms of anti-discrimination. So this is just expanding that to ensure that folks have equal rights to access businesses as their peers. And then just to address one last point, the reasonable accommodation theory that was brought up typically applies to Title I employment issues. With that, Madam Vice Chair, thank you, and I yield.
Okay, thank you for that. So I forgot to bring up, so we're going to do 2 minutes each person. So the next person in support.
Thank you, Chair. Caller with the last 3 digits of 653, please slowly spell and state your name for the record. You have 2 minutes and may begin.
Good morning, magnificent Vice Chair Neal and your esteemed committee. My name is Dora Martinez. I represent the Nevada Disability Peer Action Coalition, and I just want to say ditto to Mr. Stephen Cohen. He does bring good points. Thank you so much. Have a great morning.
Thank you for that. Anyone else in support, BPS?
If you recently just joined us, we are currently still in support of AB 207. If you would like to testify in support, please press star 9 now to take your place in the queue. Vice Chair, you have no more callers in support at this time.
Okay, so we'll move to opposition for AB 207.
If you would like to testify in opposition of AB 207, please press star 9 now to take your place in the queue. Caller with the last three digits of 859. Please slowly spell and state your name for the record. You have 2 minutes and may begin.
Good morning, Madam Chair, members of the committee. This is Janine Hansen, State Chairman, the Independent American Party. We oppose AB 207, which limits free speech and assembly on the internet, making private online discussion forums with more than 1,000 participants subject to the public accommodations law, including those which are not for profit. AB 207 on page 3, section 2, subsection 2, defines private online discussion forum as operated for the primary purpose of allowing its members to exercise their constitutionally protected right of expressive association. However, if they have more than 1,000 members, then it appears that their constitutionally protected right of expressive association does not apply because it allows the government to interfere in this fundamental right. Why is the government trying to regulate private online discussion forums, interfering with the God-given constitutionally protected exercise of free speech and assembly? Where in the U.S. Constitution or the Nevada Constitution, Article 1, Sections 9 and 10, is there a limit on the number of people, as in this bill, 1,000, who can exercise free speech or assembly? When will this number be moved to 100 or 10? How will this affect private churches which have online religious services and discussion forums and Bible studies of more than 1,000 people and may sell Bibles? During the emergency, many churches, religious organizations, and other groups met online, with many having more than 1,000 participants. How will this affect other religious affiliated organizations which may also sell religious items? How will this affect political, patriotic organizations who may join together to discuss issues and offer bumper stickers for sale? Is the government now planning to regulate free speech and assembly if more than 1,000 people participate? How is this government overreach to be enforced? This bill violates the fundamental principles of liberty. Vote no. AB 207 violates Nevada
Caller, your 2 minutes
Constitution,
are up.
Article 1, Section 10. Thank you very much.
Thank you for that. Is anyone
Thank
else
you,
in
caller.
opposition?
Yes, Vice Chair. Caller with the last three digits of 379. Please slowly spell and state your name for the record. You have 2 minutes and may begin.
Yeah, good morning. My name's Bob Russo, and that's B-O-B-R-U-S-S-O, and I oppose AB 207 for the following reasons. I have concerns that the government regulation of large online not-for-profit discussion groups could place limits on what is discussed on these forums and who those running those forums wish to invite to participate. They may also affect nonprofit groups' fundraising activities. Now, if we already have non-discrimination laws on the books, is this bill necessary? Just listening to the discussion this morning, this bill has lots of unanswered questions. The complexity and lack of clarity of it could end in numerous lawsuits. Also, will this bill restrict religious freedom and one's choice in choosing customers based on their faith and moral positions? I think it could, and thus should be rejected in its current state. Thank you very much.
Thank you for that. BPS, is there anyone else on the line for opposition?
Yes, Vice Chair. Caller with the last three digits of 616. Please slowly spell and state your name for the record. You have 2 minutes and may begin. Caller with the last three digits of 616. Please press *6 now to unmute yourself.
Karen England, K-A-R-E-N-E-N-G-L-A-N-D, with Nevada Family Alliance, and I'm calling to oppose AB 207. It is a clear violation of the First Amendment. The scope and places included in the definition of online establishment is extremely broad and truly unprecedented. Under AB 207, any for-profit or non-profit organization that merely offers goods or services to a person in Nevada is subject to the law. It doesn't require a sale being involved. Thus, a Jewish graphic designer in New York who has a website could be punished under Nevada law if the designer refused to create an anti-Semitic design at the request of a customer in Nevada. A bakery, which we've talked about, in Colorado that ships custom decorated cupcakes could be punished under this if it declined to create cupcakes that were blue on the outside with a pink filling to celebrate a Nevadan who wanted to celebrate that he was going to be identifying as a female. Even a retailer overseas in China or India could be subject to this broad definition of online establishment. AB 207 seeks to broadly extend the reach of its regulations to every corner of the country and will significantly impact First Amendment rights of countless Americans in other states. I urge a no vote on 207.
Thank you, caller.
Caller with the last three digits of 105, please slowly spell and state your name for the record. You have 2 minutes and may begin.
Good morning. My name is Lynn Chapman, LYNNCHAPMAN, and I'm the State Vice President of Nevada Families for Freedom. We oppose AB 207. We do appreciate all the questions and comments, but there does seem to be many questions relating to this bill. The one thing that we do see is that our liberties are being eroded more and more every single day. I'm directing my comments to Section 2 of this bill. Quote, without freedom of thought, there can be no such thing as wisdom, and no such thing as public liberty without freedom of speech, unquote. Ben Franklin's letter printed in the New England Courant, July 9th, 1722. In this section, there's 1,000 participants were given as a threshold. Excuse me. I wonder how long it will take for that threshold to be reduced down to less than 100. How will this section be implemented, and how will the state know if there are 1,000 participants or not? Will the state be working with big tech? How will a person or group be charged with the misdemeanor, and how will damages be figured out? We've already heard testimony and questions on that pertaining to out-of-state or out-of-the-country problems that should arise. We should be very careful. I'm not really sure that we would be careful with Section 2 of this bill. Quote, once a government is committed to the principle of silencing the voice of opposition, it has only one way to go, and that is down the path of increasingly repressive measures until it becomes a source of terror to all its citizens and creates a country where everyone lives in fear, unquote. That was a quote from a speech before Congress by President Harry S. Truman.
Caller, your 2 minutes are up.
Thank you.
Vice Chair, you have no more callers in opposition at this time.
Thank you. Anyone in neutral for AB 207?
If you would like to testify neutral on AB 207, please press star 9 now to take your place in the queue. Vice Chair, you have no callers neutral at this time.
Okay, thank you for that. So, Mr. Brody, were you supposed to do the closing comments for Assemblyman Watts on AB 207?
I can give a brief closing. I did not realize I was in that position, but
well, you don't have to be. I can just close it out. I'm not trying to put you.
That would be
okay.
That would be fine. I appreciate y'all considering this really important issue, and thank you very much.
Okay, so we will close the hearing on AB 207, and we will open the hearing on AB 190.
Thank you, Vice Chair. What a fun morning. Vice Chair, members of the committee, for the record, I am Shannon Bilbray, Axelrod, representing Assembly District 34 in Clark County. Thank you for your time today and your consideration of AB 190, which would require private employers that provide employees with sick leave to allow an employee to use such leave to help an immediate family member with certain medical needs. AB 190 would allow persons who need to take time off to care for their loved ones to use the sick leave they've already accumulated. The use of sick leave for this purpose would be to assist a immediate family member with a medical appointment or other authorized medical need. The same conditions that apply to the employee when taking such leave would apply to these with if a family has a sick leave, has a sickness, sorry. The measure authorizes that the employer to limit the amount of sick leave that may be utilized for this purpose to amount that is equal to but not less than the amount of sick leave that an employee accrues during a 6-month period. Immediate family members include child, spouse, domestic partner, sibling, parent, mother-in-law, father-in-law, grandchild, grandparent, step-parent of an employee. The difference between this program and the Family Medical Leave Act of 1993, known as FMLA, are as follows. FMLA is utilized for a serious or long-term leave needs, for example, the birth of a newborn child, adoption or foster care, or to care for an immediate family member who has a serious health condition. The AB 190 program helps caregivers with short-term health care needs. For example, to provide an immediate family member who has a brief illness, or to transport a person to a medical appointment, or to rush a person to the hospital or urgent care facility. FMLA provides eligible employees with up to 12 weeks of unpaid job protective leave per year. AB 190 program would provide access to paid leave per the sick rules of the entity. FMLA applies to all public agencies and companies with 50 or more employees. AB 190 program would apply to all employers who have sick leave. And I do want to point out that there is a trend right now that is moving to PLO, personal leave, so you can basically take time off for any reason if you need a mental health day or thing. These are actually, the AB 190 is specifically for companies that have a sick leave policy. So that means that you are sick and you take the time off. This is now my 3rd time bringing this bill, so I've sort of heard every argument. And one of the things that people have said to me is that they sometimes find themselves in a position where they have to lie to their employer and act like they're sick because their mother has an appointment or something. And where if you were allowed to do this, you could say, listen, I'm going to take an extra hour on my lunch so I can take my mom to the doctor's appointment and I'll be back in the afternoon and don't have to cough on the phone and say I'm sick. So I think this last year has really shown us how important the role of caregivers are and just how our world can be turned upside down. AARP estimates there are about 350,000 unpaid caregivers in Nevada. 1 out of every 4 workers who are age 25 or older provide unpaid caregiving. 60% of family caregivers are employed full or part-time, and 7 out of 10 family caregivers report having to make some sort of accommodations with work, and this includes arriving late or leaving early or taking unpaid time off, reducing work hours, or quitting their job, which we know has really affected women, especially in this pandemic. Another important impact to this measure is for our senior population. Once again, according to AARP and the National Conference of State Legislatures, there are 10,000 baby boomers that turn 65 every day, and each person has about a 70% chance of needing some type of support or long-term care in their remaining years. The bulk of the care that is provided is by unpaid family caregivers, and it's been found that family caregivers help seniors to remain independent. I know in 2017, I was an unpaid caregiver for my husband who was in a coma in the hospital for 3 weeks and then needed caregiving at home after rehab for several months after that. So I was very lucky that my boss at the time was worked with me a lot to see how she could accommodate me, but not everybody has that opportunity. And so that's why I thought this bill was so important. So I will, of course, remain here for questions, but I do have a couple folks who are on. I have Glenn Fuchs from AARP. He's the National Senior Legislative Representative. And I think y'all know Barry Gold, so who needs no introduction. So with that, and your permission, Madam Vice Chair, I'll turn it over to Glenn Fuchs. Thank you.
Okay, Mr. Fuchs.
Good morning, Madam Vice Chair and members of the committee. For the record, my name is Glenn Fuchs, and I'm the Director of Healthcare Access and Affordability with AARP's Government Affairs Department in Washington, D.C. I focus on health and family caregiving issues. Thank you to Assemblywoman Bilbray Axelrod for inviting me to join you virtually to discuss AB 190. Bills like AB 190 are part of a larger trend of states recognizing the tremendous work of family caregivers and better supporting them. Since 2014, over 500 family caregiver-focused laws have been enacted in all 50 states. With respect to the type of bill that the committee is considering today, a dozen states already have similar laws on the books. These bills often have strong bipartisan support, and I'm not aware of any indication that this has been too burdensome on businesses or any need for states to go back and adjust these laws on that basis. In addition, another 13 states that have state paid leave requirements allow for that leave to be used for family caregiving purposes. Assemblywoman Bilbray Axelrod has asked that I go through the provisions of AB 190 and give a summary of the bill. Some of this Assemblywoman Bilbray Axelrod has already described, and I will point out where those items are in the bill. Thankfully for all of us, AB 90 is pretty straightforward. Section 1 has
thanks. She's already started texting me.
Yeah. Section 1 has 7 parts. The first part requires that if a private employer provides employees with either paid or unpaid sick leave benefits, that the employee be allowed to use that sick leave to care for the illness or medical need of an immediate family member, in addition to the employee's own illness. So this is not requiring employers to provide extra time or extra benefits. It's simply expanding the acceptable usage for sick leave benefits that already exist. An employee's use of sick time to assist a family member would be subject to all of the same conditions as when the employee takes sick time for their own illness, meaning things like how notice is given, whether a doctor's note is required, etc. There are no potential HIPAA issues here because if the employer does choose to require a doctor's note, one can be provided with the consent of the sick family member. And I'll point out, this is exactly how it works currently when an employee takes FMLA leave. Part 2 allows an employer to limit the amount of an employee's sick leave that can be taken to assist a family member, but provides that the employee should be allowed to use at least half of their yearly sick leave amount for family medical purposes. Part 3 requires the labor commissioner to prepare a bulletin about these requirements to be posted online and in a conspicuous spot in each workplace. My understanding is that this requirement is comparable to or exactly the same as other requirements for posting information about other wage and hour laws in Nevada. Part 4 provides that employees will still have access to other benefits, rights, or remedies as may be provided by their employer or by law. Essentially, this bill is meant to be a floor and not a ceiling on employee sick leave rights. In specific, this part mentions that this bill will not extend leave available under the Federal Family and Medical Leave Act. How employers provide and treat FMLA is not touched by this bill. Part 5 prohibits an employer from retaliating against an employee for using existing leave as allowed by this bill. Part 6 states that this bill does not apply to the extent that it is prohibited by federal law. So, for example, federal law exempts certain railway employees from certain state employment laws. So those employees would fall under the prohibition here. Similar language was included in Illinois and the New Mexico bills that passed in recent years. Part 6 also excludes employees who are covered under a valid collective bargaining agreement. So this doesn't apply to them. Part 7 defines the immediate family for whom an employee's sick leave may be taken, namely a child, foster child, spouse, domestic partner, sibling, parent, mother and father-in-law, grandchild, grandparent, or step-parent of an employee. And more broadly, any person for whom the employee is a legal guardian. And then finally, sections 2 and 3 of the bill outline the enforcement mechanisms for this bill, including setting forth penalties for violation. It's my understanding, again, that these sections simply put this bill on equal footing as other wage and employment laws in the Nevada Code when it comes to enforcement. And with that, with your permission, Madam Vice Chair, I'll turn it over to my colleague, Barry Gold, the Associate State Director for Advocacy for AARP Nevada, who will discuss what AB 190 would mean for working caregivers in the state.
Okay.
Thank you. Good morning, Madam Chair, members of the committee. For the record, my name is Barry Gold. I'm the Director of Government Relations for AARP Nevada. Very famous founder of a nationally renowned caregiving institute has said there's 4 kinds of people. There's those who are caregivers, those who have been caregivers, those who will be caregivers, and those who will need a caregiver. That's what defines humanity. We take care of each other. That's what we do. People who take care of each other is just the natural, humane thing to do, and it really saves the state a lot of money. As we heard before, it is the primary source of care, and people would rather stay home being taken care of than to go in an institution. So what I want to mention is just a few statistics very briefly. AARP has this caregiving, which I know you can't see that, a report that came out in 2020. We have studied caregiving extensively, and you've heard some of those ideas already. So you've heard that 60% of caregivers still are working full or part-time, and how many people there are. We know that older workers, especially older women, are most likely to have these caregiving responsibilities, and they're an increasing part of the workforce because they now account for a more significant portion of their family's income. Their jobs and security are even more important than before. We've always known that more women are caregivers than men. It's about 60% of them are women. Lost income and benefits on average for family caregivers over 50 due to providing caregiving is about $303,000 over the course of a lifetime, and it's up to $324,000 when you look at just women. Assemblywoman Bilbray Axelrod had mentioned that more companies are moving towards just a general paid leave, and that may be true. However, sick leave is not going away. The AARP research showed that in 2020, 58% of businesses still give paid sick leave, and that's actually increased up from only that's increased to only from 50% in 2015. So more companies are also giving some kind of a paid sick leave. We also know that 3 out of 10 workers who are caregivers have had to stop working because of their caregiving responsibilities. Some people have asked, well, what happens if these caregivers abuse their paid sick leave and say they're caring for someone, and then you see them on Facebook at a lake or something? Well, the same provisions apply as if they were using the sick leave for themselves. The same provisions that you can do if they abuse sick leave, saying they're sick or someone else. It's really about, so people, as the Assemblywoman said, don't have to go, I'm sick today and I can't come in. It's having them tell the truth and be honest. What they found out is caregivers, employees are much more productive and much better workers if there's caregiver-friendly benefits in a corporation. So that's what I kind of really wanted to talk about. I wanted to also say that many businesses are already doing the right thing. Many businesses are already letting people have this humane use of their sick leave. However, many of them are not doing that. So really what we're just trying to do is to make sure that all the businesses, so Nevada caregivers who deserve this flexibility to care for their loved ones without having to sacrifice for their financial security of their families. So we're really just asking for a humane use of sick leave. And with that, we'll open it to questions. Thank you.
Thank you for that. Senator Pickard.
That's okay, Assemblywoman. I think we both graduated, but thank you. I had a kind of a basic question coming in, but Mr. Fuchs, you raised you made an interesting statement to me, and and that was that adjustments to existing state laws aren't necessary. We just adjusted this state law last session, and so clearly we think at least this one is necessary. But we passed in 2019 a requirement that all businesses, and I don't remember if there's a population cap to that in 608. I forget the section, but now all employers have to raise or provide a paid leave at a certain amount per hour worked. With that in mind, this bill seems to, and I'm not necessarily antagonistic to the thought, but this bill seems to expand the FMLA leave that is unpaid leave to now the same requirements in state law for paid leave. And that causes me a little concern because although in my firm, we don't have a problem with this because we have, we already pretty much do this. But in those particularly larger employers where you have a fair amount of turnover, these employers are typically the ones that are going to require the doctor's notes, and they don't get HIPAA releases for them. So I believe that we end up in a situation where we have employers documenting why the employee left. They take that doctor's note, and now it's still covered by HIPAA. They're not allowed to disseminate that information. But what ultimately is going to be required of employers when it comes to record keeping and privacy rights, particularly if they're recording the reasons in order to apply, as was just mentioned by Mr. Gold, that the existing rules regarding sanctions for dishonesty are still in place. How does this affect the employer's requirements and responsibilities when it comes to record keeping?
Shannon Bilbray-Axelrod for the record. So there are a few things that I'd like to sort of unpack from that question, and part of the second part of your question I will turn over to Glenn Fuchs, but I did want to reference the bill that was passed in the last session, and that was for employers that employ over 50 employees, and it was making it a personal time off, which I talked about before, which means that you could take it because you want to, Netflix and chill all day. That's fine. You need a mental health day. That's personal time off. This is actually for, I believe, and Mr. Gold can verify this, but I believe it's something like 75% of businesses in Nevada are under 50 employees, so that were not covered by the bill in the last session. So I did want to put that on the record, and then I will turn it over to Mr. Fuchs because I do think that there's some clarification that needs to, as far as HIPAA, FMLA, and what AB 190 does.
Sure, thank you. Glenn Fuchs for the record. Madam Chair, to you and through you in response to Senator Pickett's question. So regarding HIPAA, nothing in HIPAA would prevent the family member for whom a sick day is taken from allowing a doctor's note or whatever is required to be provided to the employer just to verify the employee's time off. It doesn't even necessarily need to have any more detail than that, than just the doctor verifying that fact. Yes, it would be an extra step, but the employer does not have to require this. If they do, the employee would just need to understand that this kind of documentation is going to be required. And as was mentioned, this is how it already works when an employee takes long-term leave under federal FMLA. As I understand it, if an employee takes FMLA leave to care for an ill family member, they need to submit a medical certification to the employer that includes the health information of the family member. Again, very, very basic, just that it's certified. As part of that process, the ill family member authorizes their health provider to release the necessary information. And so the process would be similar here. And again, I don't want to lose sight of the fact that we're talking about family members here, family members helping each other out. So it's really hard to imagine, too, that it's going to come up very often that the ill family member isn't willing to release some very basic necessary information so that their family member, the employee, can help them. while they're sick. And even if that were the case, employers could always adjust their policies to account for that and take that out.
Madam Chair, for the record, Barry Gold. Yeah, I can't remember the exact figure for the number of businesses that were under 50 employees, but I know it was more than 70. I can't remember if it was 72% or 78%. So the vast majority of businesses in our state are less than 50 employees, which that paid time off bill that was passed last session would not apply.
All right, I appreciate that. And I just, because I was looking for it beforehand and didn't find it, but I found it. It's NRS 6080197. It actually removed, as I recalled, the bill last time removed the cap. It's now every employer in private employment shall provide paid leave. So this bill would, as I read it, apply to every employer in the state. But Mr. Fuchs, my follow-up is this. I recognize, and I agree that under FMLA, the current practice is you get that medical necessity certification, and but that doesn't usually, at least the ones I've seen, haven't included a release for dissemination. So that can be used as proof. It stays private in the file, but now if that were ever used as part of a disciplinary action, if someone weren't telling the truth, that would be a technical violation of HIPAA. I've never heard of an action brought under HIPAA for that. But this would then require a release from the family member for the use of that information prior to the leave, and I don't know that that would be practical. But you say more than a dozen states have implemented this rule. Have we seen any litigation on this point in any of those 12 states where HIPAA was involved or the record keeping was considered inappropriate, or use of the records rather was considered inappropriate, to your knowledge?
Glenn Fuchs for the record, and Madam Vice Chair, again to you and through you in response to Senator Pickard's question. I am not aware of any litigation that involves HIPAA questions relating to these dozen states. Again, as I mentioned, the fact that these are taking place within families is probably going to nip 99% of those problems right in the bud, right? And so, again, the certification, the medical certification that requires some kind of a doctor's signature, it would simply, all you would need to add there is another line for a signature for the family member to authorize this type of a release. Again, I have to emphasize that this is only if the employer decides to require that kind of certification. Then there would be just that very minor additional step, much like FMLA includes.
Thank you, Madam Chair. And for the record, I did, as I scrolled down, I did see that the 50 is still in place. It's in Section 9 sub B. So this does exempt those with fewer than 50.
Thank you for that. Senator Lang.
Thank you, Madam Vice Chair. Thank you for being here, Assemblywoman. My question is about the 50 employees. Would that be 50 full-time employees or 50 bodies? How would you define that?
Thank you for the question. That was in reference to the bill that we passed last session. So this does not have a number. This is for all businesses in Nevada. But what the bill did last session was create a PTO. So if you have over 50 employees, you do not have a sick leave policy. You have a PTO policy per the bill in the last session. So this is trying to capture, so it will be businesses under 50, which now that you said it, Shannon Bilbray Axelrod for the record, sorry. Now that you said it was 78%. I'm 99% sure. So 78% of businesses in Nevada have under 50 employees and were not captured in the bill from last session. So,
and this bill would capture them?
That is correct.
So then my question, working for a small business with under 50 employees, a lot of small businesses have just enough employees to be able to run their day to day and really can't afford to have anyone gone, and you know, they don't have sick leave, and it's hard for them when people are gone, and this would add another layer that would impact those small businesses. So I'm wondering how you see that working.
Shannon Bilberry Axelrod for the question. You just nailed it because you said they don't have sick leave. If a company does not have a sick leave policy, this bill does not apply to them. It's only companies that have a sick leave policy.
And one more question, please. And then just one more follow-up question on that. So for businesses that do have sick leave policies, and they're using it under this bill for care for family members, but then they have their own sick leave. I could see instances where if I had to take my mother to the doctor, she goes fairly regularly, and I'd miss a lot of days, and then people end up exhausting their leave on their family, and then you never know when you're going to be sick, and then there's no sick days. So I'm just wondering if there are, in your research, if there were states that limited say a person gets a pool of sick leave 12 days a year, let's just theoretically saying, they limit the amount they can use for family members because they need some for themselves in case they get sick.
Shannon Bilberry Axelrod for the record, that is in this bill. You can only use half of the time. So if you have 10 days annually, you can use 5 of those days. But I think what you'll see is a more productive workforce, because this now allows you to say, I'm going to add that additional hour to my lunch, or I'm going to come in an hour late because of this, instead of taking the full day. So I think, and what we've seen in other states has proven my theory that you do get more productivity, but in the bill it does say only 50% of the.
Thank you for that. I just thought it was important to get those on the record.
Thank you for that. Senator Scheibel.
Thank you. I am looking at the definition of immediate family in AB 190, which I am guessing has been reviewed many a time and discussed in depth. And so my question is not about expanding it or changing it, but whether every company would be limited to this definition, or whether they could add additional people in their definition of immediate family. The reason I ask is that the relationship I don't see in there is for a step-parent-in-law, which might sound distant, but if your spouse's stepmother or stepfather is an important person to them, you may end up wanting to try to help that person out.
Shannon Bilberry Axelrod for the record. That's so funny that I didn't think of that, because my husband often takes my father to his doctor's appointments, like often. So that's exactly what that would be. I don't know if legal counsel wants to, I assume that this is the narrow scope, this is the floor, but Shannon Bilberry Axelrod, did I say that? Thank you.
Mr. Keene? Would you like to weigh in on that one?
Yes, thank you, Vice Chair Neal. For the record, Will Keene, Committee Counsel. This Section 1 provides a minimum. Employers are free to provide more benefits to their employees if they want to. They could give them more sick time. They could allow them to use sick time for more people. This is just saying what the minimum requirement is, that if an employer offers sick time, they have to offer at least half of it for family sick, and for those purposes, the immediate family are the people listed. So if an employer wanted to minimize their obligation, they could limit the employee to only using immediate family members in the definition. But this is a floor. It's not limiting an employer from doing more. Thank you.
Madam Chair, if I may, for the record, Barry Gold. We also included in there foster child, and that was really important. The Children's Action Alliance had reached out to us in a prior session and said that is a really important addition to put in there, because foster parents also sometimes have very big problems, because a lot of them are caring for foster children that have serious chronic medical conditions. So that's why you see foster child in there as well.
Senator Scheibel?
Thank you. That answers my question. I think that makes perfect sense. We could go all day describing all of the relationships that are important to people, but I think this does provide the baseline, and I appreciate the bill.
Members, any additional questions? Okay, seeing none, we will open up for support on AB 190. BPS?
Thank you, Vice Chair. If you would like to testify in support of AB 190, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 543, please slowly spell and state your name for the record. You have 2 minutes and may begin. Caller with the last 3 digits of 543, please press star 6 now to unmute yourself. Moving on to the next caller. Caller with the last 3 digits of 747, please slowly spell and state your name for the record. You have 2 minutes and may begin.
Vice Chair and committee members, my name is Andrew Lee Pilbit, last name Lepeilbet, and I represent the combat wounded veterans of the Military Order of the Purple Heart in the state of Nevada, and the 65,000 disabled American veterans in the state of Nevada, as well as I am the current chair of the United Veterans Legislative Council, representing 250,000 veterans in our state and 500,000 Nevadans when you count their family members. We are in support of this bill, AB 190. With that said, we have just one concern: the fiscal and financial impact of the smaller businesses in our state that are trying to retain employees and have started sick leave programs, those 10 to 20 and 30 employees. So we do have that concern, but we fully support this as it is a direct impact on our veterans and their families. So thank you for allowing us to testify in favor today. Thank you.
Caller with the last 3 digits of 139, please slowly spell and state your name for the record. You have 2 minutes and may begin.
Good morning, Vice Chair Neal and committee members. Misty Grimmer, Grimmer, with the Ferraro Group representing the Alzheimer's Association of Nevada. We are happy to support AB 190 this morning on behalf of all the caregivers who take care of family members with Alzheimer's and dementia. The pandemic has drawn a huge bright line around the need for recognition of the role of family caregivers. As family members felt the need to bring their loved ones home due to concerns about facility safety, or have needed to step up their role because of fears of bringing outside caregivers into the home, the burden on families has been huge. This bill helps provide protections to employees who need more flexibility on how they can use their sick leave. Thank you so much, and we encourage the committee to pass AB 190.
Caller with the last 3 digits of 194, please slowly spell and state your name for the record. You have 2 minutes and may begin. Caller with the last 3 digits of 194, please press star 6 now to unmute yourself. Thank you. Please begin.
Tom, T-O-M, McCoy, M-C-C-O-Y, Nevada Chronic Care Collaborative. Our members are Nevada advocates working together to bridge the gaps in chronic care. One of those gaps is caregiving. Representing Nevada patients with chronic diseases, we know that the need for ongoing or even short-term caregiving often goes unmet. The caregiver sick leave bill would help to meet those unmet needs. Family, caring for family. Nevada Chronic Care Collaborative asks the Senate Committee on Commerce and Labor to pass AB 190.
Caller with the last 3 digits of 969, please slowly spell and state your name for the record. You have 2 minutes and may begin.
Good morning, members of the Senate Committee on Commerce and Labor. My name is Brian Wachter, Bryan Wacchter, and I serve as the Senior Vice President of the Retail Association of Nevada. We are in favor of AB 190. A lot has been said about the paid time off bill that was passed last session, and while it doesn't apply to those employers with less than 50 employees, we believe this is a good step in the right direction to be able to make sure our employees are happy, healthy, and taking care of what they need to take care of. We think it's very important to note that the bill does not require sick leave to be offered. The bill does not require any more expenditures from a business than they are already comfortable with. And we believe that this empowers employees and employers to be able to provide the right mix of benefits that will enable their businesses to grow and eventually then become subject to the larger PTO bill. With that, we urge your support of Assembly Bill 190, and we thank you for your time.
Caller with the last three digits of 717. Please slowly spell and state your name for the record. You have 2 minutes and may begin.
Good morning, committee members and Madam Chair. I'm Connie McMullen, CONNIE, capital MC, capital MULLEN, and I'm representing my business, a small business, Senior Spectrum newspaper, and I very much am support of AB 190. This is the third time around, and I would like to say that maybe a third time is a charm, but when I was a young parent, I needed to take care of my children, and this would have come in very handy and very necessary, as we've heard. So thank you very much, and I urge your support of AB 190.
Caller with the last three digits of 656. Please slowly spell and state your name for the record. You have 2 minutes and may begin.
Good morning, Chair and members of the committee. Will Pregman with Battleborn Progress, WILLP like Peter, REGMAN. We support AB 190 to expand paid sick leave to employees caring for ill family members. This bill helps family members provide support in their time of need, whether it's taking a family member to an appointment or caring for them directly. Nevada working families deserve the chance to care for their family members. Denying time off in these circumstances puts the family member in need of help at risk, but also the well-being of the employee themselves, who can't be there for their loved one. Thank you, Assemblywoman Bilby Axelrod, for bringing this bill forward, and we urge your support.
Caller with the last three digits of 237. Please slowly spell and state your name for the record. You have 2 minutes and may begin.
Good morning. My name is Marlene Lockard, LOCKARD, and I'm representing the retired public employees of Nevada. We are in strong support of AB 190 and thank Assemblywoman Bilby Axelrod for her tenacious pursuit of getting this important legislation passed. So often seniors rely completely on family members to assist them. This bill does not ask for any additional time off or new benefit. It simply provides a person entitled to sick leave already to use for family members. Thank you so much for your consideration.
Caller with the last three digits of 122. Please slowly spell and state your name for the record. You have 2 minutes and may begin.
Good morning, Vice Chair Neal, members of the committee. For the record, my name is Katie Ryan, KATIERYAN, MEM System Director of Nevada Government Relations for Dignity Health St. Rose Dominican. I'm here today in support of AB 190, just as everyone else is apparently, and I wanted to quickly thank the bill sponsor and Mr. Gold for their continued work on this issue. Thank you.
BPS, any more callers?
For those, I'll make one more announcement.
Yeah, we have room
any
for
time
one.
left, Vice Chair.
So we have room for one more, and then we have to move to opposition.
Okay, thank you, Vice Chair. If you would like to testify in support of AB 190, please press *9 now to take your place in the queue. Caller with the last three digits of 543. Please slowly spell and state your name for the record. You have 2 minutes and may begin.
Good morning. My name is Natalie Eustace, NATALIE-EUSTICE, and I'm speaking on behalf of Nevadans for the Common Good. We support AB 190. In the past, NCG has supported legislation that helps seniors stay in their homes longer, which is what seniors prefer, and it saves the state money in the long run. AB 190 would protect caregivers of such seniors from fear of losing their jobs if they have to take time off work to take an aging relative or disabled household member to a medical appointment. I myself experienced a lot of frustration years ago. I was teaching in a private school in another state, and I needed to accompany my husband to a doctor's appointment, which was 100 miles away from where we were living, requiring me to ask for a substitute teacher for the day. I was denied sick leave because I myself was not sick. The only way I could accompany my husband to this important appointment was if I paid the substitute myself. My husband had not been able to work for some time, and as I was the only wage earner, my family's budget was very tight. However, I had to scrape together the money for the sub. NCG supports AB 190 because it allows Nevada employees to use their earned paid time off to care for their loved ones. Thank you.
Vice Chair, you have no more callers in support at this time.
Okay, so we will move to opposition.
If you would like to testify in opposition of AB 190, please press star 9 now to take your place in the queue. Again, if you would like to testify in opposition of AB 190, please press star 9 now. Vice Chair, you have no callers in opposition at this time.
Okay, so we will move to neutral.
If you would like to testify neutral on AB 190, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 124, please slowly spell and state your name for the record. You have 2 minutes and may begin. Caller with the last 3 digits of 124, please press star 6 now to unmute yourself. Thank you. Please begin.
Good morning, Madam Vice Chair and members of the committee. For the record, Paul Moratkin, M-O-R-A-D-K-H-A-N with the Vegas Chamber. The Chamber is neutral to AB 190. We were originally opposed to this bill in 2019. However, we do not have issue with expansion of the sick leave definition now, as many of our employers have been transitioning to a paid time off program because the greater flexibility offers to employees with adoption of Senate Bill 312 in 2019. I also would like to mention that many of our members, both large and small that could, have provided greater flexibility, time, and support to their employees and their families during the pandemic. Thank you, Madam Vice Chair and members of the committee.
Thank you for that. BPS, anyone else in neutral?
One more, Vice Chair. Caller with the last 3 digits of 781, please slowly spell and state your name for the record. You have 2 minutes and may begin.
Good morning, Madam Vice Chair and members of the committee. Nick Vanderpool, V-A-N-D-E-R-P-O-E-L with Capital Partners on behalf of the Reno Sparks Chamber of Commerce. I echo the statement from my colleague, Mr. Moratkin from the Vegas Chamber, and I give kudos to Assemblywoman Bilbray Axelrod on working very diligently on this issue. So thank you for your time.
Okay, thank you for that. So that's it, right, BPS?
I'll make one more announcement real quick, Vice Chair. If you would like to testify neutral on AB 190, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 584. Please slowly spell and state your name for the record. You have 2 minutes and may begin.
Jennifer Richards, Jennifer-Richards. Good morning, Chair and members of the committee. My name is Jennifer Richards. I hold the office of the Attorney for the Rights of Older Persons and Persons with a Disability, which is housed within the Aging Disability Services Division.
I just wanted to highlight for this committee some salient facts from the Elders Count 2021. The Elders Count provides authoritative data on Nevada's older adults and is a product of a collaborative effort between the Center for Healthy Aging, Office of Statewide Initiatives at the University of Nevada, Reno School of Medicine, and ADSC, which is under DHHS. Nevada continues to see higher growth rates in the population of older adults as compared to the rest of the United States. In addition, on average, Nevada grandparents are living with grandchildren and other family members, especially in Southern Nevada, at higher rates than our counterparts. Additionally, most caregivers reported having the care recipient living in their home, meaning that their caregiving role extends to 24 hours a day, 7 days a week. Because Social Security benefits are a primary source of income for many older adults in our state, that leads them to stay in the workforce longer as they age. This bill is an important step to allow for Nevadans to provide immediate care for their family members suffering from chronic conditions. The bill does not create paid time off for businesses under 50 employees, but instead provides that if they do have sick leave, those employees can choose to use that time to provide caregiving. This bill will help support the well-being of Nevadans and help older adults and persons with disabilities remain in their homes. Thank you for the opportunity to provide additional information on this issue.
Vice Chair, you have no more callers neutral at this time.
Okay, thank you for that. Assemblywoman Bilbray Axelrod, any closing comments?
I do not. I know you guys have a few more bills, so thank you for your consideration.
Okay, thank you. So we will go ahead and close the hearing on AB 190. We'll open up the hearing on AB 210.
Madam Chair.
Yes.
Madam Chair, if I may, very, very, very briefly, this is Barry Gold with AARP. If I may, I've worked with Glenn Fuchs for the last 10 years on health issues. If you've heard me testify, it is most likely that I have talked to him on these bills. I have to tell you, he recently got a huge promotion. In fact, starting today, he is now the Director of Healthcare Access and Affordability for Government Affairs for AARP National Office. And I just wanted to mention that. It has been a pleasure working with him. He does a great job, and his new job starts today. Thank you very much for indulging me.
Okay, thank you for that. All right, so we will go ahead and open up the hearing for AB 210. Go ahead.
Good morning, Vice Chair Neal, and members of the committee. My name is Julie Stramberg, and I'm the Executive Director at the Chiropractic Physicians Board of Nevada.
Is your mic on?
Oh, I think, yeah. Am I just not talking loud
Yeah,
enough? Okay, sorry.
you're doing that inside.
Sorry. My first time talking in the microphone with a mask on. I'm a little bit out of sorts. Okay, here we go. Do you want me to start again? Oh, okay, so my name is Julie Stramberg. Good morning. My name is Julie Stramberg, and I'm the Executive Director for the Chiropractic Physicians Board of Nevada. The general intent of our bill addresses four main issues. First, the first issue is to authorize the board to register, inspect, and regulate chiropractic practices that are not wholly owned by a Nevada licensed chiropractic physician. Second, to harmonize language throughout our Practice Act to use the current and modern term chiropractic physician and replace the older term chiropractor. Third, to update our licensing statute to lessen the barriers to licensing in the hope of encouraging retention and recruitment of more chiropractic physicians in our state. And fourth, to authorize chiropractic physicians to recommend, dispense, or administer lawful over-the-counter products. Madam Chair, that was a brief highlight of what our board is seeking. Would you like me to go through the entire section by section or be available for questions?
No, I think we'll just go ahead and ask you direct questions on the bill.
Okay.
So, members, any questions? I know I do. Okay, so let's just, might as well just start. Okay, so in section 4, sub 2, you're establishing the written policy and procedure for secure storage and transfer of medical records. And I guess what I'm trying to figure out is, has this been a problem? So why are you inserting this? I know why you're inserting it, but is there an issue where people have not been properly storing the records?
This particularly pertains to the language of goodness, I apologize. Julie Strandberg for the record. That's particularly addressing registering business entities, which is new this will be new language for us. So that is addressing that business entities have to provide records similar to the way chiropractic physicians already have to.
So I guess spell that out a little bit. So this is going to apply to like affiliate offices that then, is that how it's going to apply?
Julie Strandberg for the record. Apply to those practices that are not wholly owned currently by a chiropractic physician. We're asking that they follow essentially the same guidelines that a chiropractic physician has to provide currently in the law when it comes to records.
Okay. And then, I know there was another section I had a question on. It was involving I think it's in section 6, sub 2. No, it's section 7, where you're talking about if an applicant is actively engaged in the practice in another state. And so I really wanted to, can you explain that provision? Because this is an affiliate, the way I've read the bill is like an affiliate business, right? And then you have an applicant that's outside of the state, and then you're giving the 10 years, immediate preceding 10 years without any adverse disciplinary action taken against them. And so we're really trying to understand the time period, and then just give a little bit more explanation on this section of the application.
Sure. Julie Strandberg for the record. That section 7 is referring to the licensing of applicants and chiropractic physicians. So that language that is in that second section is allowing us to license chiropractors who graduated from chiropractic college prior to parts 3 and 4 of the national boards being available. So people who graduated, let's say 30 years ago, those parts 3 and 4 were not available by the national board. Our existing law requires those parts to be taken. So now we're reaching out to those folks who only parts 1 and 2 were available, but they've been practicing for several years.
So you're grandfathering them in, but you're capping them at any 10 years without any adverse action. So what if someone's at year 12, they're out?
If they've had, Julie Strandberg for the record, if they've had adverse action you're mentioning?
Yeah.
So at that point, if they've had adverse action, then we would have to address that. They would have to come before the board, and that would be a board decision at that point.
Members, any questions on? I guess not. Okay. All right, so then we will go ahead and open up for, well, no, okay, then I'm going to ask you all my questions. Okay, let's just go to section 16. So this is where you have section 16 sub 2, a chiropractor physician may recommend, dispense, or administer any drug or device for which the prescription or order of a practitioner is not required by federal or state law. I'm not clear on what that means, because when I read the whole chapter, it said nothing in the chapter shall be construed to permit a chiropractic physician to practice medicine except where authorized by subsection 2. But then it says the chiropractic physician may recommend or order not required by federal or state law. So it's the last part, not required by federal or state law, is what's bothering me. Can you explain that provision?
Yes, good morning, Vice Chair Neal. Louis Lang, I am the board's private contract counsel. When this was submitted, we tried to submit it with the words over the counter, and LCB rightly said you can't have that term, so this is LCB for over the counter, okay? And that's what we're trying to say with this language. Chiropractors do not and cannot, by law, prescribe, administer, or dispense prescription medications. And they don't want that authority. We don't want that authority through this. This is attempting to say that over-the-counter medications can be recommended or sold from a chiropractic practice. So the prescription or order for a practitioner not required by federal or state law is simply to cover both scenarios. Most of drug law, of course, is covered by federal law. But there are occasionally in state law products that are recognized by the state of Nevada that might not be recognized by the FDA. And so this would allow over-the-counter products that are recognized by the state that might not be recognized by the federal government.
So thank you for that, because, so are you required to consult with the pharmacist? What's the range of products that you have that you're contemplating that they'll be able to sell? What's the relationship on how they actually purchase these items and then put them up for sale in their office? I mean, there's a whole lot in that section, and is this currently happening? This is new. This is new, right? I mean, it's clearly new, but I'm wondering if someone else is doing this, because I guess when I go, and I'm going to use this example, when I go to the eye doctor, I don't really like them selling me anything, right? I just want to go get my freaking glasses. And sometimes they're too expensive, and so I go somewhere else. Like I go to Eyeglass World. So if I know I can go to Walgreens or CVS and go get my over-the-counter medication, why would the chiropractic physician want to sell me these items in their office? And then who is having the conversation with me about the drug interaction, even if it's over the counter? Because there can be, right? I mean, we're not talking about just giving me some, what is that, Bengay? And I'm not minimizing chiropractors, but I'm just saying that's not what we're talking about. It's a little bit more than that.
Louis Lang, for the record, Vice Chair Neal, actually that is what we're talking about. What they sell out of chiropractic practices, and this has historically been the practice, have been dietary supplements, vitamins. They don't generally tend to carry or sell, your Advil or aspirin. Those they just tell you go get some at the local store. These would likely be and continue to be things that the chiropractic practice wants to be able to sell directly to the patient that may not be generally available. Like I said, like some of their vitamins and their supplements. It also is intended to reach, and that's where the federal or state law comes in, say Nevada allows hemp oil, for example. It would be something that they could sell out of their practice rather than sending them off somewhere else to get that product. So that is the intent here. They've already are doing this. Chiropractors have been historically recommending or selling over-the-counter products out of their practices. And yes, some of them are topical. They could be topical, okay? Pain patches or creams, ointments. That's already been occurring, all right? They already know they can't do prescription medications. All we were trying to do with this is to, the board's heard my lecture 1,000 times, okay? When I represent my boards, I say, you gotta say what you mean, okay? And this is our chance. We're gonna have a bill, let's say what we mean. And if we mean to say that you can do over-the-counter medications, let's just say it. Let's put it in the law so that everybody can do so and do so safely.
Okay, so can you just say what you mean on device in that section?
Device would be pillows, sleeping aids, that they sell special bed pads and other things to assist patients to be able to sleep better or sleep in better positioning, for example. I can think of those as being devices. Those are non-prescription items that the doctor may carry. I can think of a doctor who used to be on our board who sells those kinds of products, and that's something he believes in very strongly and his patients believe in strongly. So it's pillows and sleeping devices. It might be a brace for your elbow or your back, something that would just give you a little extra support that might not be a prescription item.
So, and then just one final question, or do you not? No, do you have a question, Senator Lang? No. Okay, so the liability, so I know there's no liability on a pillow, but technically if it's in your possession, right, and then you sell it to me, and it doesn't work or it's defective, what then happens with the patient? They go back and get a refund from the doctor? Can they sue the doctor? What's currently happening in the space? You say that it's been going on, but I want to know because I feel strongly about the drug piece. I don't really, the device is interesting, but can you explain that, how the liability attaches?
Louis Ling, Vice Chair Neal, it would be the same. I mean, the liability would be for the decision that you've made. Okay, if you recommend a particular vitamin or you recommend a particular, I don't know, over-the-counter analgesic or something, your liability is going to be, as you just said earlier, you're liable for assisting the patient with that decision and what you tell the patient about how to take it. And if the patient takes it correctly, but it causes a problem, that's probably going to be with the manufacturer of that problem, not the doctor. Aspirin, for example, we all know it has certain side effects. And as long as you've warned the patient about the side effects of aspirin and you tell them to take some aspirin, I think you're covered as far as the chiropractic physician is concerned.
Okay, thank you for that. All right, so Senator Lang.
Hi. Would it be fair to say that a lot of the vitamins that you're getting from a chiropractor are more on the wellness side of the spectrum?
Want to do that? Okay. Louis Lang, yes. Senator Lang, yes. Many chiropractors, again, it's long been part of the practice of chiropractic as defined in our statutes that they give nutritive advice. So a lot of them do engage in wellness practices, and that's part of those are the supplements that they may recommend or sell.
And would it be fair to say that those supplements aren't necessarily supplements that you can go and buy like at your pharmacy? They're specialty supplements. They may be available online in certain circumstances, but they're more specialty supplements for particular conditions that the patient might have?
Louis Lang, to Senator Lang, yes. But of course, again, there's nothing in here that would require you, if they want you to take vitamin D, for example, to help with your bones. You can go down to your grocery store, you can order it online, or you could buy it from them. Okay, there's nothing in here that would require that they have to buy it from the chiropractic physician.
Thank you for that. Okay, so seeing no questions, we will go ahead and open up for support of AB 10, unless you guys have any additional comments. Okay, so anyone in support for AB 10 on the phone lines? BPS?
Thank you, Vice Chair. If you would like to testify in support of AB 210, please press star 9 now to take your place in the queue. Again, if you would like to testify in support of AB 210, please press star 9 now. Chair, you have no callers in support at this time.
Opposition for AB 210.
If you would like to testify in opposition of AB 210, please press star 9 now to take your place in the queue. Vice Chair, you have no callers in opposition at this time.
Anyone in neutral?
If you would like to testify neutral on AB 210, please press star 9 now to take your place in the queue. Vice Chair, you have no callers neutral at this time.
So any closing comments?
No, thank you very much for your time today.
Okay, thank you for that. So we will go ahead and close the hearing on AB. Close the hearing on AB 210. And open up the hearing on AB 298. Assemblyman Flores is on his way down. We'll just give it a couple minutes. Assemblyman Flores, the hearing is open. Yes, please come. Do you have a co-presenter?
I do.
Waji, you wipe the chair. Are you ready?
Thank you. Hi, good morning, esteemed members of the Senate Commerce and Labor Committee, Madam Vice Chair. I am Assemblyman Edgar Flores for the record, and I am honored to be able to be here today to present Assembly Bill 298. If I may, Madam Vice Chair, I'd like to offer a quick roadmap of how I intend to proceed for today's conversation.
Go ahead.
Thank you, Madam Vice Chair. I intend to first walk everybody through the genesis of this bill, what anecdotally was shared with me, and then I'd like to walk you through how I believe that this bill, specifically the conceptual amendment on Nellis, as that's what we're going to be working off of, addresses that very concern that I was addressed, or that was presented to me anecdotally through some of my constituents. And then lastly, Madam Vice Chair, I'd like to hand over the presentation to Ms. Romero, who is an incredibly talented attorney with the Legal Aid Center of Southern Nevada, who will walk you through the technical aspects of this bill and will explain more in depth what she sees on a daily through her profession. So to my constituents who have suffered this particular issue with leases, this bill is for you. Madam Vice Chair, I've had on numerous occasions heard of incidences where particularly members who are either not very comfortable reading a lot of technical language in a contract, and also individuals who have language barriers, who struggle with contracts because they simply do not speak the language. Talk about instances where they thought they were purchasing a vehicle and later down the road learning that they were in fact just leasing a vehicle. That is one example, and a very extreme example, of something that is unfortunately happening in places around the state of Nevada. And that's where my interest was born with this particular bill. Afterwards, I had an opportunity to work with Legal Aid Center of Southern Nevada, specifically attorney Ms. Romero, who then went on to explain numerous other issues that we have when it comes to leasing a vehicle in the state of Nevada. Namely, I also wanted to say thank you to all the stakeholders who worked with us, because they've been incredibly helpful in ensuring that we're going after bad actors and that we're protecting those that are working within the industry fairly. I also wanted to make the point that I am not in any way suggesting that it is the majority of businesses that are doing this. In fact, I would not even suggest that it's more than 40%. It's obviously a very limited amount of bad actors in this industry, but luckily the good actors were willing to work with us and resolve this issue. So if I may provide some context and just overarching background. When one purchases a car here in the state of Nevada, there are certain built-in terms prescribed in the sales contract that are not only helpful to consumers, but what they also do is they level the playing field amongst the actual industry, in that it ensures that everybody's working under the same umbrella of the same rules. And we ensure that we are not in a scenario where one business is doing one practice and another business is doing another. Levels the playing field amongst the dealerships, but more importantly, it also helps the consumer understand where they fall, right? They understand what rules are going to be applicable across the board. So that's specifically when we're talking about a sales contract. But when I first, on the onset of my presentation, I alluded to leases. And so while there's several and multiple built-in protections in the sales contract world, unfortunately the same is untrue when it comes to leasing a vehicle. In fact, outside of some federal protections that are out there already, it's almost the wild, wild west when it comes to auto leases, and there's no protections. There's nothing we've never necessarily collectively come together and created some standards across the board of what we're going to do when it comes to sell leases. So if I can give you some examples. Right now, there's currently no regulations as to the definition of default, the amount of fees that can be charged, or even what happens when people that are purchasing a car and months and years later down the road realize that they're actually leasing an agreement. They don't know, right? We don't have any rules in place presently that address that issue. And so specifically working with Ms. Romero and with the stakeholders, those were some of the things that we needed to, at a bare minimum, set that floor. There's going to be a long laundry list of very technical fixes that need to be done here, and Ms. Romero will walk you through that. She experiences this often and works with consumers in this world. But I do want to put it out there and make it abundantly clear on the record that this impacts all members of our community, from those that are incredibly uncomfortable reading a very technical contract to members of our underrepresented community that have language barriers, and communities of color, who are often the ones that are most often victimized and fall prey to some of these predatory practices by some of these businesses. In addition to that, Madam Vice Chair, if I may, at this time I'd like to hand over the presentation to Ms. Romero, who will walk you through the conceptual amendment. I want to make sure that we're all working off of that conceptual amendment. And you'll see it there as a proposed amendment for Assembly Bill 298 listed under April 27, 2021. I want to make sure you're looking at that. And Ms. Romero, who's an attorney with the Consumer Rights Project at the Legal Aid Center of Southern Nevada, will walk us through that, and then we'll open her for questions. Thank you, Madam Vice Chair.
So just really quick, all members have the amendment that he's referencing? So this isn't a part of the first reprint?
That's correct, Madam Vice Chair. Edgar Flores for the record.
Okay. So go ahead and walk us through the conceptual.
Thank you, Madam Vice Chair Neal. Good morning, Vice Chair Neal and members of the committee. Thank you for the opportunity to help present here today. For the record, and as Assemblyman Flores stated, my name is Sofia Romero, and I'm a staff attorney in the Consumer Rights Project at Legal Aid Center of Southern Nevada. Yes, and we do have the conceptual amendment because the original amendment that came out wasn't quite what we had discussed and talked about with stakeholders. So we did need to do another draft on that, which is why we are working off the conceptual amendment that's been uploaded. Before I begin, I would like to thank Assemblyman Flores for bringing this very important piece of legislation. This bill will be a much needed addition to Nevada law and solves a problem we see on nearly a daily basis. As we know, second to buying a home, purchasing a vehicle is the most expensive purchase of one's life. While not everyone owns a home, most everyone, especially here in Nevada, has to buy a car in order to get to work, the grocery store, the doctor, get their kids to school, just essentially live life day to day. Because of the volume of vehicle sales and repairs in the state, not a day goes by where somebody doesn't reach out to us seeking assistance on a car issue. Unfortunately, abuses surrounding used car leases has become the most common issue we see.
We see everything from people being repossessed when they are less than 24 hours late with a payment, sometimes despite assurances that they wouldn't be repossessed until a later date so they could have a chance to pay, to being charged upwards of $25 a day in late fees, an amount that tends to increase with time. And even people who had no idea that they leased a vehicle instead of purchasing one, despite oral assurances and representations that it was a sale. To say this is disproportionately affects the non-English speaking community is an understatement. I have sat in a deposition with a client, an older gentleman who was almost in tears because he kept having to respond to opposing counsel's question with, "I don't read or understand English," for each of the 72 times she pointed out the word lease in his contract. When after years of paying and being almost done with his lease term, his vehicle was repossessed for only being a couple days late, despite the dealership's promise that they wouldn't repossess and that he had more time to pay. When he came to our office, I am the one who had the unfortunate task of informing him that what he signed was not a sales agreement, like he had thought, but rather a lease agreement, which, unlike the sales contract that we use here in the state of Nevada, does not have a 30-day built-in grace period. A local pro bono attorney and I recently wrapped up a case where in July of 2019, a woman leased a 2003 Mercury with 130,000 miles on it. She was required to pay on the lease for a term of 115 months or 9.5 years. And at the end of the lease would still have to pay $3,359.52 in order to own the car. The reality of the matter is this vehicle would not be running 9 years from now. And even if it is running, there is no way that it will be worth $3,300. This woman, who is a native English speaker, was completely shocked when she found out it was a lease agreement, as she had thought she was purchasing the vehicle. Additionally, her vehicle was repossessed 2 days prior to the due date of her next payment, a date the dealership had confirmed with her in a text message. While it used to be 1 or 2 dealerships that engaged in these types of practices, we now not only see these types of abuses on a more regular basis, but we see them from multiple dealerships. It seems like the unscrupulous dealerships have caught on to the fact that leases do not require a disclosed interest rate, don't have a cap on late fees, don't have regulations regarding repossession. So they now have switched their business practice to exploit these statutory holes. It is because of these practices we need clear laws surrounding consumer vehicle leases. AB 298 seeks to make practices surrounding lease agreements more defined and help both consumers and legitimate businesses alike. Now I will walk through the bill as amended in the conceptual amendment. Section 1.5 puts into statute the standard default language, which is already part of every sales contract in Nevada. Again, we're not doing anything new here with regard to the definition of default or with anything regarding late payments. Those terms are already included in all of our sales contracts in the state. We have one form sales contract that every dealership must use. These terms are already included in that sales contract. We're just simply expanding this to be applicable to leases. Section 2 focuses on used car leases and requires certain terms to the lease agreement, or whether an agreement itself or an addendum. This lets consumers know the terms of default, not to sign the document if there are blank spaces. It limits the amount of late fees which can be charged to the lesser of $15 or 8% of the installment amount, which is the same as it currently is in all sales contracts in Nevada. And it contains terms regarding the residual value, early termination, and default charges. It also sets forth disclosures that the dealership must provide to the consumer and the consumer must sign. These disclosures include in bold, large font disclosure that lets the consumer know it is a lease and not a sale, and that they will not own the vehicle at the end of the contract term unless they pay additional money. To read everything carefully, because if there are oral promises not included in the writing will prevail, and that there's no cooling off period under Nevada law. It also makes sure that if the contract contradicts the statutory protections, the statute will prevail, and if the disclosures aren't provided, the lease will be considered a sale. Section 4 lays out additional protections that are already included in car sales, such as the single document rule and the font requirements. Section 5 puts forth the requirements that all spaces must be filled in prior to having the consumer sign the agreement. Section 5.5 puts in a civil right of action for people when the dealership has violated this section. Section 6 contains the definitions, and Section 7 through 10 ensure that the bill and the current statute are cohesive, and that what currently applies to open-end leases in commercial leases will now also apply to open-end leases in consumer transactions. However, an open-end lease in a consumer transaction is extremely, extremely rare. If even one happens, we usually never see them. With that, I would like to thank you for your time, and I'm available for any questions you might have.
So members, any questions? Okay, so I know I do. I'm going through the amendment. It's kind of hard to follow, though, in this amendment. Okay, so talk to me about the notice provision that you have in there. So if a company fails to put this notice out, what's the remedy?
Thank you, Vice Chair, for the question. Sophia Romero for the record. So if the company fails to provide the disclosure prior to the sale, then the remedy is we put in a civil remedy here for violating the statute. And then it would be treated like a sales contract. So in Nevada, we have a standard sales contract where the terms are all laid out and everything is set forth in statute, and the sales contract is regulated by the FID. And so we would essentially apply those provisions to this contract rather than whatever provisions it might have in the current lease agreement.
Okay. My internet literally shut down in the middle. Give me 1 second.
And Madam Vice Chair, I do have a physical printout. This is Assembly Medical First for the record, a physical printout of the actual amendment, if you'd like for me to provide that to you now.
Madam Vice Chair, and the committee members, our committee secretary is bringing printed copies for the rest of the members.
So, okay, section 5.5 in the amendment, this is the provision where you guys have the deceptive trade practices. And you have a secondary obligor under the consumer vehicle lease that may bring a civil action. Can you break that out a little bit more to explain? So you're giving the original debtor and then a secondary person the option to bring a civil action. So can you talk about that?
Vice Chair Neal, Sophia Romero for the record, thank you for the question. Yes, it's essentially a co-signer. So when you buy a car, let's say you're a younger person, you don't have established credit, you might ask your parent to co-sign. Or, for instance, a husband and wife might co-sign on a contract together. So this just essentially means that you don't have to be the primary person on the account. You can be the co-obligor, the co-debtor, and file an action as well. Thank you.
All right, okay, so thank you for that. Members, any questions now that you have the paper amendment? Senator Settlemeyer.
Thank you, Madam Vice Chair. I was just curious, so then individuals who are not signatories to the deal, but because they're an obligator, will be responsible. So I'm kind of curious how that works in a situation where you didn't necessarily know, a lot of times people nowadays don't necessarily share the same last name. So how would you potentially know that, or what problems does that create, or how will it be resolved?
Sophia Romero for the record, through you, Madam Vice Chair, to the Senator. This is only talking about co-obligors, which are co-signers. So they would have to actually physically sign the lease agreement in order to be able to either be obligated under the lease agreement or to bring an action for failure, for a violation of the statute. So they have to be signed on the contract, or else they wouldn't have standing to bring a legal matter.
If I could follow up, Madam Vice Chair, but in that same respect, if your spouse signs a legal agreement and you don't, but when in a potential divorce situation, you'd be responsible for those debts?
Through you, Madam Vice Chair, to the Senators, Romero, for the record, that would be when Nevada's community property law would take over, and that is just already standing in law. So I believe Senator Pickard might know more about this than I do on the community property issue. But yes, if your spouse, I believe, if your spouse signs a contract and it's for a necessity, then it's believed to be an asset of the community or community debt, and therefore the possibility of being liable, either having the asset or having the debt, it would be 50-50 because we are a community property state. But that falls in the realm of community property. Nothing in this bill affects that.
Thank you.
Okay, thank you for that. All right, so we will go for support for AB 298. You got off easy because.
We have nobody present in the room, Madam Vice Chair.
Right. So BPS will go to the phone lines for anyone who is on the line for support for AB 298.
Thank you, Vice Chair. If you would like to testify in support of AB 298, please press *9 now to take your place in the queue. Caller with the last 3 digits of 821, please slowly spell and state your name for the record. You have 2 minutes and may begin. Caller with the last 3 digits of 821, please press *6 now to unmute yourself. Thank you. Please begin. Caller with the last 3 digits of 821. We can see you're unmuted, but we cannot hear you. I'm going to skip to the next caller and I will try to come back to you. We are currently in support of AB 298. If you'd like to testify in support, please press *9 now to take your place in the queue. Caller with the last 3 digits of 821. Please slowly spell and state your name for the record. You have 2 minutes and may begin. Vice Chair, it seems as though we are having problems with this particular caller. Other than that, you have no more callers in support at this time.
Okay, so we'll move to opposition for 298.
If you would like to testify in opposition of AB 298, please press *9 now to take your place in the queue. Again, if you would like to testify in opposition of AB 298, please press *9 now. Vice Chair, you have no callers in opposition at this time.
Neutral.
If you would like to testify neutral on AB 298, please press *9 now to take your place in the queue. Caller with the last 3 digits of 725, please slowly spell and state your name for the record. You have 2 minutes and may begin.
Good morning, Madam Vice Chair, members of the committee. For the record, this is Andrew McKay, Andrew McKay, Mackay. I'm the Executive Director of the Nevada Franchise Auto Dealers Association. I'm here to speak from the neutral position on Assembly Bill 298. I'll keep my remarks very brief, Madam Vice Chair, but first would like to thank Assemblyman Flores, Ms. Romero, and then Bailey Bordelin in working with us on this bill. We started talking about this all the way back, and I believe it was November of last year. And they listened to our concerns, and much of what is contemplated in the amendment addresses our concerns and focus on where the problem is, and that is leasing of new vehicles. Needless to say, we were shocked when Sophia, the Assemblyman, and Bailey let us know of what was going on. And we firmly believe that what is in front of you is going to address and hopefully will eliminate this predatory practice. So for that, Madam Vice Chair, thank you for your time. Thank you to members of the committee, and again, thank you to Assemblyman Flores.
Vice Chair, you have no more callers neutral at this time.
So is the person who was trying to get on support still trying to get in?
Vice Chair, no, they have left the call.
Okay. All right. So Assemblyman Flores, can you put on the record before you close out about how the written amendment that we got actually revises the original bill, not the first reprint?
Yes, thank you, Madam Vice Chair, Assemblyman Edgar Flores, for the record. And I will hand this off to Ms. Romero. Ms. Romero, if you could just please, for the record, clarify the intent of the original conceptual amendment, how the reprint then came out, and then what we're doing now with the conceptual amendment as it stands now, just for the sake of clarity as to the work that was done with these stakeholders.
Thank you, Vice Chair Neal, for the question. So the conceptual amendment that we are working with now is different from the reprint in that the reprint that we were working off of, which would be amendment number 242, puts the default terms as required term of the contract. This puts it directly into statute and just said that this is how default is defined in Nevada. And then much more of a minor provision. It essentially changed subsection 6, subsection 5, and it just says that the dealerships cannot obtain a signature when there are blank spaces on the contract. There was an exception in there for delivery, which does not apply to consumer leases. Usually when you're leasing a vehicle, there's not a delivery issue. You just go to the dealership, you say, okay, I'm going to lease this car. You pick out the car, you take it home. So there's not that delivery aspect with non-commercial leases the way that there is commercial leases. So that is why that language wasn't needed. But other than that, those are essentially the two changes between the current conceptual amendment that we are working with right now and the amendment as reprinted.
Okay, thank you for that. So with that clarification, is everybody clear on how this amendment is working? Okay. So Assemblyman Flores, any closing comments?
Thank you, Madam Vice Chair. Again, members of the committee, thank you for allowing me the time to present this bill today. The only thing I wanted to say is just we're trying to get rid of some of those loopholes and abusive practices that are existing out there in the leasing world because of the lack of the fact that we don't have uniformity across the industry. And I wanted to once again say thank you to all the stakeholders who came together to find common ground, and specifically say thank you to Ms. Romero for her incredibly hard work. She's an incredibly talented human, so thank you for working alongside of us. And with that, Madam Chair, thank you.
Okay, thank you for that. So we will close the hearing on AB 298, and we will open up the hearing on AB 200. We are on our final and last bill. This is our 5th bill.
Thank you. Thank you, Madam Vice Chair. Shannon Bilbray Axelrod still for the record. I'm going to try to go really, really quickly because I know we have a bunch of vets who are on the call. So I'm just going to give you a really quick overview. What this bill does. In the digital age, telemedicine has emerged as one of the greatest opportunities and challenges facing both medicine and human and veterinarian. Telemedicine, when properly implemented and regulated, facilitates consultation, patient monitoring, and the delivery of consumer information and improved patient care to underserved and remote areas. In this critical time when Nevadans are more reliant on technology than ever, Nevada has an opportunity to shape the direction of telemedicine for optimal animal health and welfare benefits. To date, Nevada law and regulation are silent when regarding telemedicine. To ensure Nevada consumers can access the resources and benefits of telemedicine without sacrificing quality, AB 200 clearly authorizes the use of telemedicine in Nevada for continued care of an animal that has been previously seen by a licensed Nevada veterinarian. AB 200 formally establishes and allows for telemedicine as part of Veterinary Practice Act in Nevada. The intent of AB 200 is to provide clarity for both consumers and the veterinarians as to the appropriate use of telemedicine to treat Nevada animals. I'll briefly go through what the bill does. AB 200 affirmatively allows for a licensed Nevada veterinarian to practice veterinary telemedicine in Nevada for animals that have previously been examined. This legislation affirms that the Nevada State Board of Veterinary Medical Examiners have clear authority to oversee and govern the acts of veterinary telemedicine. This is of critical importance. Not all telemedicine is good telemedicine. By empowering the board with clear authority over telemedicine practices, this legislation ensures that in a modern age, we are ensuring the highest level of consumer protection. This legislation will expand the access to veterinary care. The legislation enables both clinical and education assistance to underserved and remote populations. This legislation codifies the existing regulations that require a physical examination of an animal to establish what is called the veterinarian client-patient relationship, the VCPR. That is actually already in our regulations, and so this is just codifying it into statute. So I'm going to actually turn this over to Alyssa Nave. I have more, but I know we're on a time crunch, so I'm going to thank you.
Hi, everyone. Vice Chair Neal and the members of the committee, thank you so much for your patience today, and I will quickly go section by section through the bill. With us today is also Dr. J.J. Goycochea, Dr. John Pennell, and Dr. Susie Costa, who have been waiting with us and going in and out and seeing clients. I think that's where Dr. Costa is. Once I go through this section by section, I'll turn it over to first Dr. Goycochea, then Dr. Pennell, and hopefully Dr. Costa. Section 2 of the legislation defines veterinary telemedicine. This definition was drafted to be consistent with federal law to ensure clarity for consumers and veterinarians alike. Section 3 of the legislation clearly states that the veterinary telemedicine is an appropriate tool to be used to treat Nevada animals for ongoing treatment once a timely veterinary client-patient relationship has been established through the physical examination of an animal. It has been Nevada law for over 20 years that timely physical examination is required to establish a VCPR, which is a legal term of art. Section 3 brings that requirement, currently codified under NAC 638-0197, into statute. This makes Nevada law consistent with the majority of the states and also ensures that telemedicine, when used as an appropriate tool, is consistent with the federal law governing telemedicine and pharmaceutical prescription. Section 4 of the legislation allows for telemedicine by a veterinary technician who is supervised by a licensed veterinarian. Section 6 revises the definition of the practice of veterinary medicine to include telemedicine and makes certain exemptions of those activities that are exempted from the definition. There is also a proposed friendly amendment requested by the Nevada Board of Veterinary Medical Examiners that I've been asked to present. Again, this is considered a friendly amendment and is available on Nellis under my name. I believe the board is available today here to answer questions. The proposed amendment does a number of cleanup items that they believe is necessary for the oversight of veterinary medicine, unrelated to telemedicine. It removes a notice requirement requiring publication of various news outlets if personal service cannot be made. It would allow the board to accept licensure applications online by removing the requirement for notarization. It would allow the board to hold renewals on a biannual basis and move the renewal expiration to June 30th, which is a less hectic time for licensees to conduct renewals of their licenses. The amendment would allow licensed veterinary technicians to administer zoonotic vaccinations such as rabies in addition to veterinarians. It would allow the board to review consumer complaints and make recommendations as a full board or as a committee. This would streamline the process for investigation complaints. And finally, it allows for an inspection or committee to issue a letter of correction, which be limited to certain areas of practice. The intent is to fill the gap the board often finds between actions that are either disciplinary or non-disciplinary. And again, Nina Laxau, I believe Jennifer Pedigo will be here to answer that portion of the friendly amendment. And with that, I would like to turn over my testimony to Dr. JJ Goicoechea. Or I'm open for
I have to
questions.
stop you. So I'm going to have to suspend the hearing and come back. We actually have the Titus speech today on the floor, which I forgot about that. So we actually have to get to the floor on time, and then we can come back. So I had this bill at the last because that's what the chairwoman requested. So you guys will have to come back and present after floor.
After floor today.
Yeah, because we have a Titus coming in.
Sorry, for the record, Alyssa Nayworth.
Yeah, I apologize, and I apologize to everyone that is out there, but I just literally, that's what I was just told, that's what I have to do.
Again, for the record, Alyssa Nayworth, we will work diligently with our veterinarians to appear, and if not, we will have to certainly submit their testimony on record if necessary,
So if it doesn't work, we'll just have to reschedule it. And probably the better thing is probably to reschedule it for Wednesday and allow you guys to have a hearing with enough time for your support, opposition, and et cetera. So that probably makes better sense to go ahead and just have that hearing on Wednesday. And I'll just let the chair know, because honestly, I think that's fair. Not to have to come back after floor, because I don't know what the schedule is for other committees. So we'll just reschedule this for Wednesday, and I'll let Chair Spearman know, because I don't know how that's going to work based on our schedule over here.
again, for the record, Alyssa Nayworth, we'll have to work with our veterinarians as they cleared their morning patient schedule this morning.
I understand.
So we'll just have to we'll make it work.
I get it. So I'll talk to Chair Spearman about making you guys the first bill for the Wednesday hearing. But I am being told we have to suspend and get to the floor.
Okay, thank you so much.
Madam Vice Chair, are we adjourned?
Sorry. Yeah, I am adjourning Senate Commerce and Labor.